here that Mr. Ngubane is not there. And similarly as B Zulu
Not cited.
is not cited as well. So there is no, we don't have a resignation letter, we don't know why those two who were conveyed, and you'll see that these were appointed not for a short period of time, they are appointed for 4 years. So if they were appointed in 2022, we are now in 2024. There ought to be an explanation of why they are not part of the.
But why? I mean, if you had cited the two, Ngubane and Zulu, then one would have expected the minister to say, well, I appointed them, but they're no longer members, they resigned or something like that. But you didn't cite them, so there seems to be no dispute about who the members of the board are.
No, so we make a positive allegation that the appointment process followed by the minister leaves a lot to be desired in the sense that I've just described. And I accept the proposition you put to me that perhaps if we had cited them, the minister would have come in and said, but they are no longer members because of A, B, C, and D. But we pertinently raise the fact that the people that she tells us are members of the board are not a great number of them, and we've cited them in our papers, who those are that are no longer in the are no longer in the board. Actually, they're not members of the board, but the minister indicates in a number of her letters that these are people she appointed as board members. But the point about the minister, my lord, is really the point that buttresses a point we make about the fact that in these proceedings we were asking for interim order. In paragraph 4, I think in a way what paragraph 1 does takes care of paragraph 4, because we've clarified that what we're after is the legal costs, the funding, any legal litigation involving the lawfulness of the first respondent's decision to recognize the seventh respondent as king. So it would fall under the legal costs that we've clarified for in paragraph 1.
Yeah.
That's our paragraph 4. So if paragraph 4 is catered for under paragraph 1, we don't have to repeat it. But paragraph 5 is...
So 3 or 4, one must be dropped.
Yes.
Okay. And 4, as it stands, is the final interdict.
No, I think we also,
Rather
because
go
we
with
can't ask for a final interdict, we're asking for an interim interdict.
Yeah.
So we would accept a similar amendment that pending the outcome of paragraph of part B, then the 4th and the 5th respondent are interdicted from utilizing the public funds in paying the legal costs of the second respondent rather than the personal interest.
Paragraph 5 is very expansive.
Yes, paragraph 5 is
And
paragraph 5 is really costs to be paid by respondents. There's that formulation which says each paying. Can I reformulate it, and in reply my junior will deal with that amendment to paragraph 6 is too expansive.
so,
Yes,
so number 5 we're going to deal with in reply.
yes. It's the one paying the other to be absorbed, yeah. My Lord, you have no idea how happy I am to suggest to you that unless you have any questions, I intend to sit down and say to your Lordship that Mr. Smelane will deal with the reply. So for the moment today, I will be sitting down with no outside this intense environment.
Yeah. Thank you, Mr.
My Lord, those are submissions. Thank you.
Mr. Murani, I think you are next.
Yes, my Lord, but we are going to be brief.
I'm sure there will be no objection to that.
As Lord, please. Lord, bit of chronology. The applicants in this matter, they brought a similar application earlier on under a different case number, lots and lots of pages, but it was a totally defective application, with the results that they withdrew that application in 2 stages. The first stage was where they withdrew the application in respect of some of the respondents on the 25th of October last year. And then on the 26th of October, they withdrew the application in respect of all the respondents. Then on the 13th of November, they brought this application. Incidentally, they didn't tender the costs of the abortive application. But I suppose in an attempt to try and put Humpty Dumpty together, they brought this application. But still, in this application, there were matters of fact or allegations which related to the first, the second, and third respondents, which were not correct. So what the first, second, and third respondents did was to file explanatory affidavits just to correct the incorrect averments. With regards to all three of the respondents, they responded to paragraph 10 of the founding affidavit, which appears to implicate all three respondents in unlawful conduct. Paragraph 10 said the following: the purpose of this application is manifold. Broadly, it is to stop the 8th to the 20th respondents from unlawfully dissipating the financial resources of the Ngonyama Trust in support of the personal interests of the 7th respondent. It is also to stop the government respondents, in particular the 2nd to 5th respondents, and I represent the 2nd and 3rd, from unlawfully spending public funds in support of the 7th respondent, insofar as that is done on the basis that he is a king of AmaZulu. Now, just to pause there, there's absolutely no allegation in the whole papers that the 2nd and 3rd respondents are supporting the 7th respondent in unlawfully dissipating the financial resources of the Ngonyama Trust. So that is one of the allegations which each of the respondents have responded to in their explanatory affidavits. Another allegation is one that appears in paragraph 37 of the founding affidavits, and that reads as follows. The 10th respondent is Inkosi Thanda Mzimela, the chairperson of the Ngonyama Trust, appointed as such by the 3rd respondent. Now, that is incorrect. The 3rd respondent did not appoint Inkosi Thanda Mzimela as the chairperson of the Ngonyama Trust. Now, the next allegation, which is challenged by the respondents, or some of them, is paragraph 45 of the founding affidavit, wherein it is recorded as follows: our attempt to stop the coronation ceremony, where the president publicly handed the recognition certificate to the 7th respondent, failed on the basis that the court found that the application lacked urgency. That is correct. The court in that application accepted the submissions made on behalf of the 7th respondent, that we had alternative remedies that could be activated, such as reviewing and setting aside the president's decision. While this is correct, it would render review applications superfluous if the government respondents continue to offer financial and administrative support to the 7th respondent. What was taken in issue there, my Lord, is the statement that the government respondents which, as far as we are concerned, included the first, second, and third respondent, continue to offer financial and administrative support to the seventh respondent. There's absolutely no basis for that. And the next allegation, which was dealt with by the respondents, or some of them, that is 1, 2, or 3, paragraph 47. What has bolstered the seventh respondent into acting with bravado and impunity is the unlawful financial support that is dished out to him by the government respondents, and then in brackets, in particular, the Premier and the Ingonyama trusts. But to the extent that the President and the second and third respondents are government respondents, that is a statement which has absolutely no basis whatsoever. Then the next series of allegations that were disputed, particularly by the second respondent, are those that appear from paragraph 100, where the opening statement is the following. During 2016, the second respondent, the Minister of Agriculture, etc., acting in terms of Section 2A of the Ngonyama Trust, appointed members to the board. The term of the board ended on the 30th of June 2020. Now obviously, my Lord, the second respondent had nothing to do with all this. And in her explanatory affidavit, she disputes this. I noticed that in the replying affidavit, the applicants say that, well, this was an error, and they further say that the second respondent, in her answering affidavit, is trying to mislead the court. We find that allegation rather rich. Instead of apologizing and saying that, well, they actually made a mistake, they dragged the second respondent in error, they say the second respondent is trying to mislead the court. We find that attitude really untenable. Then the next paragraph is 139. Now, 139 says the following: I understand that I will be entitled to supplement this founding affidavit once the first respondent, that is the President, has filed the record of the proceeding in this matter in terms of Rule 53 of the Rules of Court. It is common cause that the President has got nothing to do with this matter. So that is one of the issues which is corrected in the explanatory affidavit. Now, what the applicants have argued is that the third respondent has not filed an affidavit which disputes certain matters in the founding affidavit. But, Lord, what they seem to ignore is the terms of that affidavit filed by the third respondent, and these are at page on 801, from 801 to 807. Yes. Lord, I'll only read what I consider relevant and material parts. Paragraph 3. I must state up front that I do not oppose Part A of this application, but only Part B. I will file my opposing affidavit once the applicants have amended or varied the notice of motion and or filed a supplementary affidavit in terms of Rule 53 sub 4, should they elect to do so. Then 4, although I abide the decision of this court in respect of the relief sought in Part A of the application, there are certain allegations in the applicant's founding public funds to the 7th respondent through the Ingonyama Trust, and it is therefore unclear why the applicants have included me amongst those respondents mentioned above. Then I've already dealt, Lord, with paragraph 37. I shall not repeat that. Then she also mentions in paragraph 15, in paragraph 15 that I'm not cited, nor was I involved in the case mentioned in Annexure PM1 to the founding affidavit, nor in its sequel in the Supreme Court of Appeal. She was not involved in those proceedings. Then, finally, and the Lord, we submit that this is important, particularly because in the replying affidavit, the applicants do not deal at all with this particular paragraph, paragraph 16. In fact, they don't deal at all with the affidavit of the 3rd respondent. In their sort of consolidated replying affidavit, they deal with other matters, and they specifically deal with the 1st respondent. They deal with the 2nd respondent. They don't deal at all with the 3rd respondent. So this particular paragraph is not disputed, and I'll read it out. That although, as I've stated in paragraph 3 above, that I shall file a comprehensive affidavit at a later stage, may I take this opportunity to deny that I've committed any unlawful, improper, or irregular act in the discharge of my functions and duties relating to the King, the Ingonyama Trust, or the Ingonyama Trust Board as alleged by the applicants in the founding affidavit. So this is a broad denial of the substance of the case brought by the applicants. So we submit that the criticism leveled against the 3rd respondent in particular is unwarranted. Those are submissions.
Thank you, Mr. Morgan. Mr. Swillen.
Thank you, Lord. Lord, I'm going to confine my submissions to 2 aspects. First is the purpose behind why the Premier is not opposing this application. And the second is the legislative framework set out in the explanatory affidavit. Lord, considering the notice of motion, my learned friend Mr. Masuku took his lordship through the notice of motion, and particularly to the Premier is the paragraph which states of the unlawful and unauthorized funding. At the time of the decision not to oppose, it was based on personal interests. We have now, Lord, the amendment to that to be legal funding. And so, Lord,
Sorry, I can't hear you. Say that again?
Apologize, Lord. I said initially, the notice of motion stated that sought an interdict preventing the authorization of funding for personal interests. But now, my lord, we have a situation where those words are deleted and amended with the words legal funding.
Well, it hasn't quite been done in relation to paragraph 5, but I expect it to be done.
Indeed, well,
Yeah.
indeed, my lord. The point is, my lord, the purpose of not opposing is capsulated in the final paragraphs of the explanatory affidavit, stating that no funding was allocated for personal use. And my lord, the entire framework that I propose we deal with is that the seventh respondent that we're dealing with is cited in the official capacity as seventh respondent. The funding that has been allocated is allocated to the seventh respondent in their official capacity. And so, my lord,
It could have, all of that could have been made clearer in the explanatory affidavit. I mean, there is evidence in the papers that provincial government is of a mind to assist the seventh respondent in the litigation. No more than that. There's no evidence that it has actually been done.
mhm,
And when it's done, that's when when a decision is made that it should be done, it'll be that decision which may be subject to legal scrutiny
yes,
if the power does not exist.
mhm.
But at the moment, there's nothing.
None, my lord, except the budgetary allocations set out in the explanatory affidavit.
Yes. Now, do you argue that that allocation may cover legal costs to defend the positions of royals who may be under attack as to their status in the royal household?
My lord, insofar as the legal costs are dealing with the office of His Majesty, and I'm using that word specifically in terms of the Trust Act, or the Royal Zulu House Trust, then yes, because in the next set of submissions, the Zulu Royal House Trust Act sets out explicitly that, firstly, in terms of Section 15, the funding is appropriated from provincial government, dedicated towards the benefit of the Zulu royal household and the monarch, who the head is the king. His Lordship will note that in the Trust Act, the words His Majesty is defined as the monarch. And those same words, His Majesty, is where the budget allocation is allocated to, page 582 of the papers. And so, my lord, to answer your question, yes. Pardon me, 536, I apologize, my lord.
Sorry, just So your argument is you've disclosed the budgetary provision for legal assistance.
Yes, and that budgetary allocation is in terms of the Trust Act, because that allocation, if His Lordship sees the third bullet point towards the latter part of the page, it says 30 million was allocated to Program 3 towards legal fees incurred by the royal household. The funds are split between goods and services to cater for His Majesty the King's legal costs. Now, what those legal costs are for, I I submit that the explanatory affidavit does not disclose that. I say I submit the explanatory affidavit does not disclose what those legal costs are for. But the point is that legal costs have been allocated for His Majesty the King in terms of the Trust Act.
Are there other renditions of this vote in these papers?
Yes. Indeed, my lord. The first is Annexure A, which is the pre-adjusted vote. That is on page pardon me, my lord. Yes, that is on page 482.
What's the difference between that one and the
Yes,
and C at 5, starting at 533, which
Indeed,
is what
Lord.
we've been looking at?
my lord, that's I will take his lordship through it, but that's dealt with in paragraph 21 of the explanatory affidavit. That's the legislative or budgetary process that's followed. The first vote in Annexure A is vote 1, that's the first vote. That vote then goes through the Appropriation Act, which is Annexure B. Appropriation Act is then published, and then there's an adjustment of the vote that occurs thereafter. So the second vote,
Are they all called vote 1?
yes, well, I appreciate it. The adjusted vote 1, if I may put it that way, is Annexure C.
C.
And so, my lord, the decision as it stands would be Annexure C, that is the adjusted budget. And that's the reason why that budget states that a 30 million was allocated. Of course, the 30 million is split between the household and His Majesty's services.
You say upon a proper construction of the Trust Act, it's legitimate to do so.
Indeed, my lord. Lord, the long title of the Act's specific part is to determine the manner in which the Zulu Royal House Trust is to be managed, governed, staffed, and financed. The Zulu royal family, or rather the Zulu royal house, means the traditional institution of the royal family of the monarch, according to Zulu customary law and customs, and in turn the royal family is defined as royal queens and blood relatives of the monarch. The monarch themselves is the monarch of the province of KwaZulu-Natal, being the person holding office as the king of the Zulu nation at the date of commencement of this act, or the monarch of the province as may be subsequently defined in the constitution of KwaZulu-Natal.
If what you're saying is correct, is the position not that the government could be financing the first applicant's costs? He's a blood relative of the monarch. He's
Yes.
dealing with a matter similar, well, he's dealing with the other side of the matter in the case against the monarch.
Indeed, my lord.
Technically, that could be funded as well. Is that your argument?
Well, no, that's not my argument, but what I'm saying is I'm agreeing an
Counsel
interpretation.
on my right here are looking very intently at you. They want to hear the answer.
Well, my lord, the Act does state that the trust in section 3.1 that the trust must, in a manner consistent and within available budget and resources, be administered for the benefit of the monarch and the other members of the Zulu royal house. including, so not exhaustively, their material welfare, education needs, aspirations, and social well-being. And Annex C, the adjusted budget, makes that allocation for the Zulu Royal House.
Yes,
As
about
well as-
50% of those costs are to the Royal House.
Approximately 50%.
We don't
yes.
know what litigation that has to do with.
Yes, we don't. I don't, and I don't have instruction in that.
I mean, for all we know, the Queens who were challenging the appointment of the seventh respondent may be financed out of that 14 million rand. We don't know.
We don't, my lord.
Okay.
But to answer your question, that is the definition in terms of the Act. And so, my lord, my submission is that the explanatory affidavit sets out why the allocation is not for personal use. And as to the source of power, I was asked to answer, my lord, that's not the case that I was called to answer, but the Act does answer that nonetheless. And if the issue is with that allocation, then we're either talking of an executive decision to allocate that budget or a legislative decision to vote that budget, and that's not the case before His Lordship. And in any event, my lord, the order crowd principle will still have to be dealt with. And lastly, my lord, the reason for the explanatory affidavit was to assist this court in determining the issue of separation of powers when interdicting an organ of state. His Lordship would know that the outer judgment requires exceptional circumstances over and above the interdict. And since these are dealing with public funds, that's the final reason why that explanatory affidavit was filed, to assist this court with the issue of separation of powers and whether the interdict will be infringing on that. So my submission is that the funds are allocated legitimately and within due process, and that's the purpose of the explanatory affidavit and for not opposing the application. Those are my submissions.
Thank you. Mr. Badenhorst, I believe you're next.
Next.
Yeah.
Look, my learned friend stands in for me as a consequence of flu and all sorts of problems.
Oh, I'm sorry about that, Mr. Baden. Mr. Cropper.
May it please the court. My Lord, I intend answering to the submissions of my learned colleague on behalf of the applicant in broadly two sections. The first section I intend to deal with some points in limine that we held over following the submissions and arguments on urgency. And then subsequent to that, I will then deal with the merits or lack thereof relating to the relief sought in an interim interdict and its requirements. By way of introduction, my Lord, I wish to start with the issue of lack of locus standi, but by way of introduction, I want to make the following submissions: that it is the seventh respondent, King's case, that the applicants simply have no locus standi on the basis what they have submitted in their founding affidavit as who they represent in these proceedings. When one now considers the introductory paragraphs of the founding affidavit deposed to by the first applicant, in paragraph 2, he says, "I depose to this affidavit on my own behalf as the eldest surviving member of the ruling family of the Zulu royal family, the Indlu Bushwa. And I also depose to this affidavit on behalf of the members of the ruling family of the Zulu royal family and the core members of the Zulu royal family who are close relatives to the ruling family. My Lord, I submit that there's simply no evidence in support of the notion that the first applicant deposed to an affidavit speaking as the voice and the self-appointed spokesperson of the royal family. One would have perhaps expected to see evidence of a family meeting being called so that a resolution can be passed authorizing the first applicant in particular, but any of the applicants before your lordship, to stand here today in court and to say that we act and our voice is the voice of the royal family. Because, my lord, it creates the impression that what is submitted on behalf of the applicants in this application is indeed the will and the voice of the royal family. And I submit nothing could be further from the truth. Nothing whatsoever. But it goes further, my lord. In paragraph 3, the first applicant says, I bring this application on behalf of the Ubukosi, as also referred to as the kingship of the kingdom of AmaZulu, which forms the core identity, unity and strength of the Zulu kingdom. And then he proceeds to say that for this purpose, Isilu, the Ingonyama or king, is the head of the kingdom of AmaZulu and Amakosi, the body thereof. It would also appear that the first applicant says, I'm even standing here on behalf of the king. And that simply cannot be true. He is the 7th respondent in these proceedings and is opposing the relief sought in this application. Also, my lord, there will be no explanation as to who is referred to when the applicant refers to the ruling family. And I submit, if one now considers the position of the applicant, it would appear that the applicants before your lordship are 4 members who claim to be members of the royal family. And as much as they may be members of the royal family, they most certainly don't speak on behalf of the royal family.
All right, but look, we can go round and round in circles on locus standi. The first question you haven't addressed. He says, I appear on my own behalf. And I take it, read in context, he's saying so do the other applicants. They are senior members of the royal family. They are senior in age. They are senior members of the Zulu nation, certainly to the extent that to the extent of their interest in the clans which are beneficiaries of the Ingonyama Trust. And they come along and say this case is about misuse of Ingonyama Trust money. Does he lack, and do the others who signed their confirmatory affidavits lack locus standi to do that?
My lord, indeed. And I will address your lordship on the further issues relating to the lack of locus standi. So by way of introduction, I just want to make it absolutely clear that when your lordship considers the facts and the averments that's left in the founding affidavit subsequent to the striking out of paragraphs, it must be considered against the backdrop of the factual position that this by no means can be said to be the voice of the royal family. I.e., if your lordship is inclined to accept that the first applicant, second, and the other 3 applicants together, that makes up the 4 applicants in this application, have indeed locus standi insofar as they are members of the royal family, one has to accept that it's a minority voice.
Yes,
It's not the will of the...
Well, I accept that, but I mean, I'm not going to be swayed by democratic principles here. This is not an exercise in democracy or politics. The question is, do they personally have locus standi?
My lord, I submit they don't, and I will address your lordship on that issue. The royal family, and for this purpose I need to perhaps just take your lordship to the affidavit deposed to by the 4th respondent, and I submit this is of importance to just have an understanding of where all the different entities fit in. And if I can take your lordship to the explanatory note, my learned colleague on behalf of the fourth respondent had briefly set out before me. There are a few issues that I need to point out. My lord, for the convenience of the court, I have prepared a bundle of authorities, and just for the convenience of the court, we've emailed it to our opponents. It's the bundle of, it's in our heads of argument as well, but it also has just a copy of the different acts, the Ingonyama Trust Act, the Royal House Trust Act, and also the AmaZulu Act, just for convenience.
Is that the 1990 Act?
I
That's
think
been
so, my lord.
repealed.
The KwaZulu-Natal Ingonyama Trust is the 1994 Act,
Yeah.
and then in the KwaZulu-Natal Royal House Trust is the 2018 Trust, and then the third one is the AmaZulu Trust, is the 1990 Act. Indeed.
Is that the repealed Act?
That could possibly be, my lord.
Yeah.
But for purposes of just identifying the parties, we've prepared this bundle, and I beg leave to hand it up if it will be of assistance to the court in
It may very
just
well be.
following my
assistance.
arguments.
Yeah.
I beg
I
leave
thank
to
you
hand
for
it up.
that. Don't you want to go?
My lord, the first aspect that I want to deal with, and take your lordship to, is the perhaps the first, the Ingonyama Trust Act, and your lordship will find that from page 1. But in particular, I want to take your lordship to page 2 of the Act, and then clause 1 of the bundle, and I just read from the Act. Paragraph 2, clause 2. The trust shall, in a manner not inconsistent with the provisions of this Act, be administered for the benefit, material welfare, and social well-being of the members of the tribes and communities as contemplated in the KwaZulu AmaZulu, and I will not pronounce that name, but I will just refer to it as the Inkosi Act 1990. I will not endeavour to be known as one that is not doing justice to the Zulu phrases. I bow to your superior knowledge on the issue, my lord. Now, of paramount importance, my lord, is the fact that in this Act, because it's a trust that was established by statute, it specifically states who are these beneficiaries. They're the AmaZulu. I take your lordship then to the second
No,
Act
hang on.
that starts on
Wait.
page 6.
You say the AmaZulu are the beneficiaries of the.
They say, if I read paragraph 2, it says that this trust shall be, in a manner not inconsistent with the provisions of the Act, be administered for the benefit. So those must be the beneficiaries. For the benefit, material welfare and social well-being of the members of the tribes and communities as contemplated in the KwaZulu AmaZulu Act.
Yeah, but it's a quite different thing to say that it's for the benefit of the Inkosi themselves.
Well, I refer to them as representative of their tribes. Is that in this Act I submit, and in the workings thereof, they then represent their different tribes.
Well,
Even
maybe
when-
that's one of the big problems with the Ingonyama Trust.
My Lord,
The distribution
may
of
be-
funds to the Nkosi
Yeah.
instead of to the community, assuming distribution of funds is any business of the trust at all.
My Lord, I submit it will probably depend on whether, in what capacity they would receive funds. I can make no submissions in that regard because that's not part of my brief.
Yeah.
The point that I'm trying to establish is who are the beneficiaries of this Ingonyama
Well, this
Trust.
court has already held that the beneficiaries are the individual members of the various communities. They're now scheduled in a schedule.
Indeed.
They're identified in a schedule to the Act.
And they are in fact listed.
Yeah.
But further than that, my Lord, if I can take your Lordship to the KwaZulu-Natal Royal House Trust Act.
Yeah.
This is from page 6.
Of the bundle you've given me.
Yes, ma'am.
Yeah.
And then specifically, if I may take your Lordship to page 3 there, well, on the bundle. It will be page 12.
Yeah.
And in clause 3, on the objects of the trust, say this trust, the trust must, and in a manner consistent with the provisions of this Act, and within the available budget and resources, be administered for the benefit of the monarch and the other members of the Zulu Royal House, including their material welfare, educational needs, aspirations, social well-being, benefiting their status. And then it proceeds to say what the trust can do. But then it goes further in clause 4, on the same page, my Lord. It then says, for the purposes of this section 3, the Zulu Royal House consists of the royal queens and those blood relatives of the monarch whose names appear in a list provided for from time to time by the monarch to the premier. So there's a list, a numerus clausus of royal family members who qualify to benefit under this Act. My submission in this regard, my Lord, is the following.
Well, hang on a second. As I understand the customary law on this issue, the house you belong to is determined by the identity of your mother. So persons who are part of the Zulu royal family, are you saying this Act says only the queens themselves, but not their families?
No, my
Are part of-
Lord. The list.
No, the
would
list is
probably
an
incorporate
addition.
all of them.
The list is an addition to the royal queens. If you're not with the royal queens, you may be on a list of blood relatives of the monarch who appear on the list. But if you are of the royal queens, or if you are the royal queens, you're automatically fall under section 3.
Indeed.
Yes. Okay.
That is indeed the case.
Yeah.
But the issue of locus standi, my Lord, finds its application in these different sections of these two trusts that I referred to, Your Lordship, is that the royal family, per se, are not beneficiaries of the Ingonyama Trust. Those are the Amakosi and their tribe members as defined
Well,
in
I hope by saying that you're not trying to persuade me to write a judgment based upon the proposition that the Amakosi are beneficiaries of the trust,
not at all, my Lord.
in their capacities as such.
Yeah, indeed, my Lord. They
It's
are
the
defined-
members of the community. They're the beneficiaries of the trust. This court has
Indeed,
already held that.
Yeah, indeed, my Lord. And I'm referring to how it is just referred to in that paragraph 2, clause 2 of the KwaZulu-Natal Ingonyama Trust Act. The point and the submission that I want to make, my Lord, is that those tribes, those communities that falls within the ambit of the Ingonyama Trust are not the royal family. They have their own trust that makes provision for them. So my submission is that if the applicants come and they say, we are members of the royal family, we represent the royal family, even if that's not the case, in their own capacity as members of the royal family, and we take issue with the administration of the Ingonyama Trust and the trust board of the Ingonyama Trust, I submit, my lord, they are disqualified from doing so on the basis that they have no locus standi. It would be the tribes.
Can I make a note now? You're saying, if I got this right, the applicants approach the court personally. When they say personally, they do so as members of the royal family. But the members of the royal family are not beneficiaries of the Ingonyama Trust.
Indeed, my lord. That's my submission.
That's the point.
That's my submission.
Did the seventh respondent not say in his affidavit, did he not identify the community of which the first applicant at least is a member and that it falls within the ambit of the trust?
My lord, I need to.
I'll never track it down, what I have in mind while we sit here.
I look at paragraph 2 of the founding affidavit, how the first applicant proposed to and identified himself. But the importance of my submission, my lord, turns on the issue that we submit the applicant, even in that capacity, and the other 3 applicants inclusive, they are not the Amakosi as per Section 2 of the Ingonyama Trust Act. The Ingonyama Trust Act makes no mention of the royal family, and we submit on that basis that for purposes of locus standi in this matter, being a member of the royal family does not give you the locus standi. But it goes further, my lord, and whilst we're on the subject in dealing with these documents, I want to follow on that submission. If one now considers the explanatory affidavit of the 4th respondent and the annexures thereto, and if I may take your lordship back to page 536, it is part of Annexure C of that explanatory affidavit. In the bundle, it's on page 536.
Okay, this is the vote you're looking at.
Indeed. But towards the middle of the page, underneath the bullet points, under the other adjustments dealing with the 50 million allocated from National Treasury for the purpose of these expenses, the 3rd bullet point that deals with the 30 million, it says the 30 million was allocated to program 3 towards legal fees incurred by, and this is very important, it's by the Royal House Trust.
The Royal Household.
Royal Household Trust. I do apologize,
It doesn't say the trust. It just says by the Royal Household.
but it's been dealt with. The Royal Household Trust, my lord, is being dealt with and managed financially by the Premier. And then it says these funds are split between the goods and services, and then it proceeds to say cater for His Majesty, the King's legal costs and transfers and subsidies to departmental agencies and accounts for transfer of the Zulu Royal House Trust for the royal family's legal cost. These funds are specifically and exclusively allocated, may not be used for any other purpose. So legal costs are being dealt with by this trust, not by the Amakosi and the Ingonyama Trust and by the Ingonyama Trust Board. So these funds, my lord, have been allocated not to the Ingonyama Trust, they've been allocated to this trust. But this trust, and in terms of the trust deed, and I need not take your lordship there too, it's in the trust deed, has its own board of trustees. They get elected for that purpose. And I submit, my lord, that if that was ever the issue, these funds made available by the 4th respondent through this process, part of the National Treasury and the budget, it obviously required these trustees of this trust to be a party to these proceedings. It's their money. As much as in process and in execution and administration, the Premier would be affecting these payments. It is the trust funds that are being allocated and disbursed for that purpose. So, my lord, my submission is on that basis. The applicants have no locus standi to attack the Ingonyama Trust and the Ingonyama Trust Board and their administration from his position as a member of the royal family. This issue has been made, and if I look at the prayers, the relief sought, there's now interim relief sought, and I specifically perhaps prayer 5, if I may take your lordship just back to the founding and to the notice of motion. The relief sought in prayer 5, as it stands now before any amendments thereto, interdicting and restraining the 4th and 5th respondent from utilizing or authorizing in any manner or form the utilization of any public funds and resources in promoting and supporting the personal interests of the seventh respondent. Those would be the funds of the trust,
The household trust.
the household trust.
And you say he's got no locus to dabble in the affairs of the household trust. Is that your argument?
My Lord, being a member of the royal family, he's part of that trust. But they are trustees, but they are not party to these proceedings.
So it's a
But
joinder issue.
It's a joinder issue, but it also relates to the locus standi of a royal family member who now comes and attack the Ingonyama Trust and the Ingonyama Trust Board to say that we take issue with your decisions and with the financial management of the Ingonyama Trust, because that jurisdiction or the locus standi to do so would be to the beneficiaries of the Ingonyama Trust, not the beneficiaries of the Royal House Trust. Those are my submissions in that regard, my Lord. And on that basis, we submit the applicant does not have locus standi to deal with these issues. And in any event, and it's indeed a joinder issue, my Lord, these are sometimes so intertwined. But even on the relief sought against the fourth applicant, our fourth respondent, it can never be if the trust are not party to these proceedings, because the allocation is clearly to the trust. My Lord, my last submission in this regard is the following. This dealing with these funds is not a decision of the Premier. It is a vote by the provincial legislature. The court will be violating the separation of powers by overturning a budget passed by the provincial legislature not to allow these funds to be disbursed as allocated and budgeted for. And I now refer specifically to the funds that was made available for covering the legal cost of the king so in office. My Lord, I apologize. I did not see that we've gone past the...
No, the magic hour is at 11:15. Let's carry on.
I do apologize. I must have got my watch wrong, but I will then proceed, my Lord, because I may be able to deal with quite a few issues in these 14 minutes. My Lord, I then want to deal with the issue that closely linked to this point in limine, the issue of non-joinder. The misjoinder issue I'm not pursuing, as your Lordship had made a ruling on the second, third and fourth applicants in that regard. But the non-joinder issue, my Lord, indeed we submit that the trust, the Royal House Trust, should have been cited, should have been part of these proceedings. And my Lord, in addition to the trust itself, who has its own trustees and is managed by the trustees, this would most definitely be a matter that needs the attention and input from the royal family members. But they're not cited. And they're not cited, my Lord, because the applicant says, but I represent them all. And we submit, my Lord, that is fatally flawed, because the royal family, no doubt, has a material interest in the outcome of this application and the interim relief sought. I may also sorry, no. I may also just mention, my Lord, that in all the previous matters, and in particular the review application in Pretoria, the royal family was duly cited, and they've been party to those proceedings. And to deal with these matters, and the royal family not formally being made party to these, I submit, my Lord, is a matter of non-joinder, and on the basis that the material interest that the royal family would have on the outcome of this application requires of them at least to be granted this opportunity, that if they deem it necessary, to be represented and to have their own voice here. One would have to consider this specific issue, my Lord, also on the basis what my learned colleague had submitted, that the main thrust and the main issue that they need to deal with, and my learned colleague had made that submission yesterday more than once, that it's important to understand that where the applicant comes from, where they approach these matters, is they've adopted the approach that His Majesty the King has not been identified, recognized and inaugurated properly. He's unlawfully, they use the word in their papers, he's unlawfully in position. Now, we know what the status is with the pending appeal currently in the Supreme Court of Appeal. He is in office, he is the King, and he should be dealt with on that basis until a competent court decides otherwise. But they, as the applicants, make that submission that everything has to be coloured or been considered against the backdrop of their position that they consider him to be unlawful. On that basis, my Lord, I submit it's even more so required that the royal family be cited, that if they then so wish to have their own representation, to make their own submissions as to how they see the way forward, they most definitely have a voice to give input, especially for the relief sought in this application, especially if one considers the dire consequences, even of the interim relief, for them as well, because effectively that would even impact on the payments on behalf, in terms of the provisions of the KwaZulu Royal House Act, because the funds that my learned colleague has presented being paid by the Premier are in fact those funds, and that would no doubt have an impact on how they have to execute, and the trustees of that trust more so on how they would execute their duties in that capacity. So, my Lord, those are my submissions on lack of non-joinder, and I submit that those are all dispositive of the application. I then want to move on to my third point in limine, and that is the issue of Elizabeth Lenz. My learned colleague had yesterday said he only has one sentence about that matter, and then he just made one submission in that regard. But I submit with respect, my Lord, the position is quite different. What the applicant fails to point out to your Lordship, insofar as that specific outstanding issue, is that this application was also launched on an urgent basis in the North Gauteng High Court on the 4th of July 2022.
Which application?
An urgent application, my Lord, for similar relief as what we have before your Lordship today. I intend to deal with those specific prayers to point out the similarities, my Lord. The application was set down on the urgent application roll on the 26th of July of 2022, when the Honourable Bom J had struck the application from the urgent roll on the same day, 26 July 2022. Of significance, my Lord, is the fact that subsequent to that matter being struck off the urgent roll, The matter has never been withdrawn whatsoever.
Isn't there a debate going on at the moment in Pretoria or Johannesburg or both as to the consequences of an order striking out an application for want of urgency? So it's presented as an urgent application. The judge says it's not urgent. I strike the application out. And I seem to think that recent authority says that is the end of the case. Other authority says, no, it's not. You can put in an amended notice of motion in the long form and present it as an ordinary application. I'm not quite sure what the position is now in Pretoria and Johannesburg.
My Lord, I am afraid I have to admit that's my neck of the woods. That's where we practice on a daily basis. The practice, and I stand to be corrected. I will endeavour to address your Lordship on that during break. I will endeavour to get the. But as we practice today, once a matter is struck from the roll on basis of lack of urgency, it is then merely placed on the normal opposed roll, and it will then follow the normal course.
But it can't do that because the respondents have never been given the appropriate notice so that they can consider their position and file proper affidavits.
My Lord,
If that were the case, the judge would say, okay, now I'm making a further order that the respondent can file an affidavit by such and such a date or something like that. That would keep it alive, but that's never done.
Yeah, indeed, my Lord. In Pretoria, we follow what we commonly refer to as the Southwood rules in our practice directive that gives the timelines of what needs to be done to make a case ready for the what we would then refer to as the normal urgent role.
Yeah.
Extremely urgent applications normally follow totally their own rules as provided for in Rule 6. But in the normal course, which was in this case, there would be timelines given and you need to abide by those as much as possible, and if you cannot do so, you will then make your submissions at the hearing of the urgent application.
No, what
But
I
on
mean
that
is,
basis,
what I mean is when the judge says I'm striking it off the roll, it's not urgent. That's the end of it. The respondents have only been given, for argument's sake, 2 days to put their answering affidavits in. They've never been notified that you've got 15 days to put your answering affidavits in. Which is why in this division, certainly, the very least that has to be done to resurrect an application struck off the roll for urgency is the delivery and service of a long form of notice of motion given the usual terms of notice.
my Lord, that's not how we deal with urgent cases in Pretoria Division, absolutely. But
Just look up to see if I'm right.
I will-
I'm thinking
I will-
that there's
I will
been some
endeavour to-
recent debate about this in your division. And,
I will
and
endeavour to get that information, my Lord. All I can submit is that if the matter is being struck for lack of urgency and that's the end of the case, then the application in itself must be dismissed. The whole purpose of merely striking it off the urgent roll is to say you don't belong on this roll, you need to go to the normal opposed roll. But I will endeavour to get that information for your Lordship. However, my Lord, I need to just point out that in that application, and I need to confirm the position, and I will do so, but I'm referring specifically to Pre 4.1 and 4.3. My learned colleague has made a submission that they're not the same relief, but I want to perhaps just read Pre 4.3 and your Lordship will see the similarities.
have you put up the notice of motion, haven't you?
My Lord, we have the notice of motion. It's in the papers. I will just have to. It's Annexure KZ9. It goes from page 757. At the paragraph that I'm referring to, your Lordship will find on page 759.
Should we take the short adjournment while you sort out what your next submission is going
Perhaps
to be?
that would be the most opportune time. Thank you.
If I can just make the observation that speaking for myself, but it's your decision, I would be happier if we spent more time on the merits of this case than on points in limine.
My Lord, I'm just about done. I will then be.
We rise for the short adjournment. We'll resume in 15 minutes.
No, no, thank you. Thank you very
Just in case.
My Lord,
The
we've
relief
dealt...
sought starting at page 759 and this case.
Yeah. My Lord, may I perhaps assist the court just on this basis, that in paragraph 12 of our heads of argument, it's on page 55 of our heads, we've dealt with the this issue right up to page 60. And we will, in our heads of argument, we will stay and leave the matter at our submissions in our heads of argument. Those are our submissions. Before proceedings, if I may just perhaps have a moment to consider what the position is, and we may have a different approach on this matter of lis pendens, and I don't want to waste the court's
Am
time.
I right
on-
in thinking it's a dilatory plea? Yeah. Okay.
Indeed, my Lord. If I may then, my Lord, then proceed to the merits of this application, because those would be our next set of submissions that I wish to make to your Lordship.
All right. Well, then I've got a primary question which I need answered with an explanation. In the seventh respondent's affidavit, he says words to the effect, "I see nothing wrong with the Ngonyama Trust paying my legal costs." Are you arguing that it's perfectly all right for the Ngonyama Trust to pay the seventh respondent's legal costs in connection with the challenge to his, let's call it his throne?
My Lord, indeed, and I need to perhaps give it context. My Lord, when we were in chambers yesterday, your Lordship had made mention, I have noticed that perhaps that is not abided by as far as the media's presence is concerned, and I am of the opinion that perhaps your Lordship need to address this. I have just noticed it on the one side.
Yes.
Perhaps your Lordship need to address that issue.
Perhaps I could ask your instructing attorney to speak to the cameraman to your immediate right, instead of doing it on air, so to speak.
May I just have a moment? My Lord, I want to address the question that your Lordship had posed. It was also submitted yesterday by my learned colleague, and he made reference to the correspondence relating to the payment of legal fees to Strauss Daly. In the letters, and I will refer your Lordship back to those which was then under discussion and submissions were made, was correspondence between the then chairperson of the Ngonyama Trust Board, Mr. Ngwenya, and Strauss Daly, and then to the board first to record that he has received this request from His Majesty, and secondly that they should consider doing those. In those letters, and when we go back, your Lordship will note that there's a reference made to certain disbursements and also a 5%, and the request was from the disbursements that we still owe the King, and also that 5% payment, is it possible that we could then assist him in making these payments or some arrangement with Strauss Daly? It's not on the papers, my Lord, but I believe the parties, and perhaps my learned colleague, speaking for the 8th and 9th respondents, would be able to confirm this. It's my instructions that there's a disbursement policy in place as far back as 2006, which affords some payments to those members of the board for whatever the policy says, but that was a policy that was approved and it's been already implemented and in place since 2006. And it may also be that, because unfortunately are left now to speculate on the issue, but it relates to payments that they said there was
Did you
payable
not
to.
get the supplementary affidavit from the board delivered shortly after the last hearing, where the disbursement policy is put up?
My lord, that would come to great assistance.
Or did you not get it?
My lord. It would appear that my attorney did receive it, my lord. If I may, my lord, I will come back to that question. I don't want to waste the court's time. I'll deal with the other issues and then come back and deal with that issue. I want to make submissions on the disbursement policy.
So, okay, so are we heading in this direction? That as long as it forms part of the 9%, 5%, which the policy seems to say is due to the king, the costs can be paid.
Indeed, my lord, those are my instructions. That was the way, or shall I put it, what the administration of the trust in the board had approved. Now, it may indeed be, and I take from what my learned colleague in the affidavit would most no doubt come and submit to your lordship, is with the new board that came in subsequent to, shall I call it, the board under the chairmanship of Mr. Ngwenya, the new board may take a different view. And I take from what the affidavit says on behalf of the 8th and 9th respondent that there's a revisit of those policies and a revisit of all the, shall I say, the rules and policies that they've implemented over the years, and that they ensure now, more than ever before, that they deal with disbursements of funds strictly in accordance with what they are authorized to do as the Ngonyama board. But I have no doubt that my learned colleague will address your lordship on that issue. What is of paramount importance, my lord, is that we are left to speculate as to what the content of that agreement with Strauss-Daly is. And as your lordship quite correctly pointed out yesterday, in the absence of Strauss-Daly being a party to these proceedings, it will remain a mystery as to what was discussed, what was agreed upon, and what are those terms and conditions, and more so, my lord, the origin of those funds. Are they Ngonyama Trust funds in the sense that there was no disbursements due and payable to His Majesty, or not? It may well be making reference to the 5% and other disbursements to the King, that those funds may have come out of that, but it remains pure speculation, because Strauss-Daly is not before court to be able to explain how they engage with the Ngonyama Trust on that basis, and whether they have subsequently received funds from another source.
Strauss-Daly, the issue has to do with historic costs.
Indeed, my lord.
And there some other historic costs which presumably have already been incurred in connection with certainly the Pretoria matter, which has gone to the Supreme Court of Appeal. We don't know about the arrangements for payments of those. But I'm a bit confused by the trust approach to this thing, because I get the impression when I read the affidavit put up on behalf of the 8th and 9th respondents, which is after all just the Ngonyama Trust, that there is no argument about the principle. The Ngonyama Trust has no business paying the legal fees of the king in connection with his own affairs. And indeed, it'll be also in connection with the royal house affairs. Those are dealt with, as you pointed out, under different legislation.
Indeed,
But then they say they oppose this application to the extent that any order made interferes with their powers to make disbursements in terms of their disbursement policy. Right? And although the affidavit fudges it, because it says it qualifies it, when you read the disbursement policy, there's a 5% tax on all Ingonyama Trust money and income which goes to the king, and a 10% tax which goes to the Inkosi. That's what the policy seems to say, to be. Now, and they have said that insofar as we're paying Strauss daily, we're doing so under the 5% heading. So is their position that they can pay your costs
Well,
as long as it falls within the 5% or what?
My Lord, I have two submissions to make in that regard. The one perhaps is that if the policy to make certain disbursements is in any way attackable, it most definitely can only be attackable by way of a review application. Secondly, my Lord, when His Majesty the King takes up the position of the King of the Zulu Nation, he automatically becomes the trustee. He is then, in that position and in that office, empowered to either become the chairman, well, in fact, the Act says he becomes the chairman of the Ingonyama Trust Board, or he may appoint his nominee.
Yeah.
If any one of those two positions, that's my submission, my Lord, if any one of those two positions, him as the trustee of the Ingonyama Trust, or as it currently stands as the chairperson of the Ingonyama Trust Board, if that is under attack, my submission is that a case can be made out that the Trust Board or the Ingonyama Trust may then provide legal assistance through legal fees to defend their duly appointed trustees, so in office. But that, my Lord, I submit, does not fall within the ambit of personal expenses or personal coming to the financial assistance of His Majesty on the basis of his personal needs. That has to do with him taking up the office of a trustee, the only trustee in the Ingonyama Trust. And in that position,
The Ingonyama Trust can provide funds to protect him against an attack on his status as trustee and or chairman.
those are my submissions.
So they could fund this case because of paragraph 2.1
Indeed,
of the notice of motion.
indeed, my Lord.
Okay.
The same would apply to the members of the Trust Board, should they be subject to this type of attack, because it now relates to the institution, the trust as a juristic entity. It's a rather unique statutory trust. My Lord, I will then proceed to deal with the merits, and I want to start with the requirements and perhaps limit myself to making submissions under the headings of the 4 requirements for an interim interdict, and then make my submissions and expand on that basis, my Lord. My Lord, I want to deal with the requirement of a prima facie right that has to be made out, and by way of introduction in dealing with that specific requirement, I want to perhaps start off by making reference to the case of the National Treasury and others versus the opposition of Urban Tolling and Alliance and others. Your Lordship will find that in my bundle on page 91. It's a Constitutional Court judgment of the Honourable Magweng, and more specifically, if I may refer Your Lordship to paragraph 47, and that Your Lordship will find on page 105 of the bundle.
Doesn't
In
that
the
deal
middle
with
of that-
balance of convenience?
Indeed, my lord, but the principle that is in the middle of that paragraph, and it deals with the following, towards just above, a line above C. It says a court must keep in mind that a temporary restraint against the exercise of statutory power, well ahead of final adjudication of a claimant's case, may be granted only in the clearest of cases and after a careful consideration of separation of powers harm. It is neither prudent nor necessary to define clearest of cases. And then further on, my lord, to paragraph 65 of the same judgment, and your lordship will find that on the bundle on page 109, but it is page 109 of the bundle, paragraph 65. Again, just above C, just the one sentence that I want to highlight, my lord. It must assess carefully how and to what extent its interdict will disrupt executive or legislative functions conferred by the law, and thus whether its restraining order will implicate the tenet of division of powers. Now, my lord, I say that by way of introduction, because if one now considers the relief sought in this interim interdict against those qualifications of what it must pass muster on those issues, and we now look at what case was made out, what prima facie right has the applicants established for this interim relief. We submit, my lord, that they've made out no prima facie case, and I want to start off again where I started this morning. The applicants are members of the royal family. They are not beneficiaries of the Ingonyama Trust. They are not board members of the Ingonyama Trust. And the attack is clearly twofold. The first attack, and this my learned colleague had made very clear, that the overall covering attack is on the what he purports to be the lawfulness of the identification and inauguration of the seventh respondent as the king.
Mr.
And
Copper,
everything submitted.
I think your learned opponents said at least twice yesterday that in arguing this case, he's got to accept the position that as matters stand, the seventh respondent is the king. And this morning he abandoned paragraph 2.1 of the Part A relief. So the only questions left then, and I don't think they turn at all on the challenge to the propriety of the appointment of the seventh respondent as king. I don't think they turn on that at all. Is this question of legal costs. It seems to me to be all that's left. If I'm wrong, correct me, please.
My lord, it would appear, indeed, if those were the missions, and your lordship understand that, I'll leave that point. I've just noted how many times repeatedly it was said against the backdrop within the bigger scheme of things, so to speak. And
your learned colleague doesn't want me to forget that there is a challenge to the appointment.
But my lord, it brings me to my next submission
Yeah.
on the issue of, is there a prima facie case? Is there a right in need of protection? Because not only must there be a right, but it must now be in need of protection. My learned colleague, in what he has then submitted as to where we stand currently with legal proceedings, we submit, my lord, that because of the existence of section 18 sub 1 and 3 of the Superior Courts Act, which would be the remedy for where we stand in terms of the review application which deal with that subject matter, what other right? Because if I now consider the rights of the applicant in terms of pending litigation as we stand, the only right which I submit the applicants have at this stage to deal with relief of this nature is to approach the High Court in Pretoria in terms of Section 18. Because what we deal with now is no longer, as the notice of motion wants to suggest, a pending review application in Pretoria. We've gone past that stage. We're now in the Supreme Court of Appeal with a pending appeal. Thus, the provisions of Section 18 now finds application. But on this application and the relief sought here within the context of where we're at with the appeal in the, shall I refer to it as the main review application in Pretoria, the only available right that the applicants may have is to approach the High Court in Pretoria in terms of Section 18. We also submit, my Lord, that that's the only alternative, or that's one of the alternative remedies available to the applicants.
But what's the Pretoria Court case and the Pretoria Court itself got to do with the payment by the KwaZulu-Natal provincial government of your client's costs, or the payment by the Ingonyama Trust of your client's costs?
Well, my Lord,
It's got nothing to do with the case that's gone to the Supreme Court of Appeal, surely.
my Lord, other than Section 18, we submit that the applicants have made out no case for any rights in need of protection in this particular matter.
Okay.
I'm suggesting that there's possibly an alternative remedy as one of the requirements. If there's an alternative remedy also it disqualifies the relief sought. But other than that, my Lord, my submission is that the applicants failed to make out any case and provide evidence of any right that they have dealing with Ingonyama Trust and Ingonyama Trust funds from the position as royal family members.
Now, that's back to the locus standi question.
Indeed, my Lord, but even if one had to accept, in terms of the prayers that they, I'm specifically referring to prayer 5, relief against the fourth respondent, we submit, my Lord, in that capacity again, with all due respect, it would appear that they're barking up the wrong tree, because the Ingonyama, not the Ingonyama Trust, the Zulu Royal House Trust are the recipients of those funds. They have their own board of trustees, and if there's any possible attack on the way they manage those fees, the correct entity to have been party to these proceedings would have been the trust. And those are my submissions, because now we're referring to what we have in this case as a prima facie right. Well, there's none. There's none. The seventh respondent is in position, and we submit surely on what my submissions in terms of how his court cases are funded at this stage. There's absolutely no right of the applicants in need of protection. In fact, we submit that they have made out no prima facie right even, because as members of the royal family, even in their own trust, of which they are party to as beneficiaries, provisions are made for these expenses to be incurred, following due process. And there's no evidence to suggest that due process have not been followed. My Lord, I also want to then make reference to the matter of Tenants Williston Court versus Leray. They're also in the heads, but I'm not going to quote anything that it's in the heads of argument, but it also just deals with this issue. And perhaps,
Well, sorry, can I have the name again so I can find it in your head?
I apologize, Tenants, T-E-N-A-N-T-S,
T-E-N.
Williston, W-I-L-L-I-S-T-O-N, Court versus Leray Investments.
What page of your heads will I find the citation?
My Lord, I'm working off oral heads now. My Lord, my learned colleague says he has not incorporated into the bundle. I do apologize. I've made reference here on my oral heads, and I don't want to waste the court's time. It deals with how you apply Section 18. So I'm not going to make a quote from the bar concerning that.
But you say it is referred to in your heads, your written heads, or not?
Yeah. My Lord, it would appear that we've taken that out. It's just in the oral heads. I was going to just quote it, but
Well, have you got the reference in your oral heads?
I have, my Lord.
Can you give it to me?
I can give your Lordship that. It's 2016,
Right.
in bracket 6, SA 466, and the relevant portion thereof, my Lord, is at 466. 466. 466 at,
At 466.
yeah. And then the relevant portion is GD at 470 G
470.
to 471.
Thank you.
It's paragraph 18 and 19 of that, Judge. My Lord, then turning to the next qualification or requirement for the relief sought. Again, my Lord, on the issue of irreparable harm or the threat or fear or irreparable harm being done, we submit once again, and I have to now make the submissions based on even what the 8th and 9th respondents in their affidavit had submitted and alleged, my Lord, is that with the new board that came into power, they diligently follow procedure. Historical payments are just that, and they cannot deal with that. They can deal with what they have now moving forward, and they've made their position very clear, how they approach it. The 4th respondent, the other purse, so to speak, through the, I have to say it right, the Royal Zulu House Trust, the Zulu Royal House Trust. Again, the position was made very clear by the 4th respondent in the explanatory affidavit as to what the position is regarding further payments and the process that is followed there. Now, my Lord, if one considers that to be the current position, the question is, what harm would the applicants be suffering? What harm can be apprehended?
Well, the question is what harm can befall the interests which they seek to protect?
Again, my Lord, on that basis, we submit that there is no harm in the current position in need of this protection. The interim interdict is there for the purpose of protecting an interim arrangement pending the review applications.
But do you say that because, according to the Ingonyama Trust and its board, they don't intend to pay any legal costs?
Well, my Lord, that would appear to be the position,
Yeah.
because
So
there's a budget.
there's no anticipation of future harm, and there's a disclosure of past harm.
Indeed, my Lord. And the court must take note of the fact that the whole payment to Strauss Daly is not the making of the applicant in its founding papers. It was the 8th and 9th respondent that made those submissions by explaining what they've inherited, so to speak, from the previous board and how they are dealing with this matter currently. But, my Lord, even so, we now know, and that's my understanding, is that the only payments or the only budget, whether there's payments that there's no evidence of, but the only arrangement or budget for any legal fees on behalf of the king would appear to be those that is budgeted for in the trust the house trust, nowhere else. And that's the evidence before your Lordship. And on that basis, we submit there's no risk as suggested by the applicants in this regard. My Lord, lastly, my submission on the issue of irreparable harm. Perhaps the applicants' interest, the applicants are contrived because the interests that can be protected are perhaps only those of the AmaZulu, because they are the if I say AmaZulu, I refer to the tribes represented by the AmaZulu at meetings. I keep on saying the AmaZulu because of the act, but of the tribes that fall within the ambit of those beneficiaries that form part of the Ingonyama Trust. And clear distinction between them and the royal family members. And those interests...
But the royal family members belong to one of those, or more.
Well, my Lord, the Act itself makes no mention that royal family members are in fact incorporated into... And my submission is with the provision, the separate provision of the Royal House Trust for royal family members. That would indeed not be the case, my Lord, that they would form part of the beneficiary group of the Ingonyama Trust. Those were my submissions that I made.
You say, in fact, they're not community members as defined, as contemplated in the Ingonyama Trust Act.
My Lord, surely
Sorry,
they
I
look...
just want to make a note. Yeah, sorry.
My Lord, then, just in closing with irreparable harm, the test in this regard is an objective one, so one needs to look at the facts objectively. And when we consider the facts presented by the applicant that we submit consist of hearsay and speculative averments, we submit that the issue of irreparable harm finds no application in these proceedings and in these circumstances. Then I move on, my Lord, to the balance of convenience. I need not say much or make much about the balance of convenience if one now weigh up the rights of the parties concerned. I submit that no doubt the balance of convenience must favour the respondents, and more particularly the seventh respondent. He is currently the reigning king. The balance of convenience where we are, and I'm specifically referring now to the position which the applicant holds. It's common cause that the parties are engaged in protracted litigation. It's been in the making since 2021 already. The seventh respondent, as the king of the Zulu nation, finds himself in all these litigations as one of the defendants or respondents in all these matters. He's in office. He's the reigning king. Surely, the applicants don't want to stand before this court and say that their whole purpose of having all these applications, and particularly this application against him, is to cut off every possible financial assistance for him to cover legal expenses, having to defend his position as the reigning king. My Lord, that would simply be untenable. If one now considers what would be the outcome of this interim interdict, that would be the situation. So if one considers the balance of convenience, we submit it favours the 7th respondent and also those other respondents, including the 4th respondent and the 8th and the 9th respondent, in having to deal with matters as they have clearly made out their position where they currently stand in terms of policy and execution thereof. The last issue, my Lord, is then the issue of no other satisfactory remedy available. My Lord, we dealt with the issue of Section 18. I made my submissions. But perhaps there's another alternative remedy that the applicant have in these situations. Any decisions taken by the Ingonyama Trust Board, or, well, they're not even a party, so I won't make my submissions on the other trust, but on the Ingonyama Trust Board, if there's any decisions that the applicants may feel that they have a right to attack, surely the alternative relief would be to take that on review.
Any future decision?
Any future decision, absolutely. Absolutely. There would simply just be no possibility for them to deal with the past. I mean, and I'm sure my learned colleague for the 8th and 9th respondent will address your Lordship on that issue comprehensively. So, my Lord, in conclusion, if I may then just summarize, just going back to the notice of motion, and I've heard my learned colleague on the prayers, but perhaps if I may then just summarize in conclusion. Going back to the notice of motion and the prayers, based on what my learned colleague's submissions this morning, it would appear that prayer 2 is no longer in play in its totality. So prayer 2 is dead. I submit, my Lord, that on these facts, prayers 3 and 4 are also dead. And I'm making reference to disbursement policy and my submissions there. Prayer 5 is the only issue that I want to make the following submission on. My Lord, we submit that prayer 5 also cannot stand and should also fail, purely on the basis that the budget of the Premier is passed by the provincial legislature. It's been dealt with, it's been placed before your Lordship, and the court should not interfere with those in this interim interdict proceedings. And on that basis, we submit that prayer 5 also cannot stand. My Lord, my last submission before I close. I want to reiterate just one important point. We're dealing with the 7th respondent in the office of a king. And it only came about once he was duly inaugurated as the king by the first respondent, the President of the country. And on that basis, my Lord, we submit this application, this interim relief sought here simply cannot be successful and should fail on the basis and the legal and arguments and submissions we've made in this regard. Those are my submissions for the seventh respondent,
Thank you, Mr. Klopper.
as it pleases the court.
Mr. Dixon.
May I just digress before I start my argument? I listened very carefully to the Lord's questions about own interest litigants. And the Lord might remember that the Lord took part in a case called Giant Concerts versus Ronaldo Investments. That's where it's all set out. And it distinguishes an own interest litigant with an litigant who's bringing it in the public interest, bringing a case in the public interest under Section 38. And that principle, and that case went on to decide, as well as my Lord will recall, that that point can be dealt with as a discrete point without getting into the merits. The second point that arises from that case is in Lawyers for Human Rights versus the Minister of Home Affairs. I've got the reference if my Lord is interested in it. 2004, Volume 4 SA, page 125, Constitutional Court, at paragraphs 14 to 18. It deals with what a litigant has to say to bring itself within Section 38. And the conclusion is that it must be more than just a statement. It must be elaborate, and the court must decide objectively whether this person is genuinely bringing the application in the public interest. I don't know whether that, my Lord, helps my Lord in that
I'm
issue.
sure that will help me on. Is it in either of those cases that what is said is you've got to examine the question as to the litigant, whether the litigant is the right person to do it?
Yes, it's actually
Is that
Giant Concerts, where it
Giant
says you've got
Concerts?
to have the right cause of action by the right person against the right respondent.
Yes, that's right.
And in many ways, that argument raises the question in this case, whether the applicants are the right person to be bringing this case.
Because of their, because they're in fact conflicted almost.
They've brought...
They get the advantage of litigating against somebody who can't fund his own litigation.
Well, let me just say straight away that the Ngonyama Trust is not paying anybody's legal fees.
Yeah.
And so I know that my Lord is going to ask me that question. And I'll take my Lord through the disbursement policy, which no one's attacked. No one's wanting it to be struck down or set aside. But it's quite clear from a reading of it in totality that the seventh respondent is not entitled to have his legal fees paid. And the affidavit that's put up by the Ngonyama Trust makes it quite clear that we were stuck with a serious problem from the past. We had to honor it, but no more. And that's a point that I'll be refraining throughout my argument.
Yeah.
But I think just to finish this point, it seems that the members of the royal family who constitute the applicants are clearly bringing it in their own interests. And I don't think there's anything in the affidavit which says we're bringing this on the part of the general public or the public interest to stop an organ of state paying money to the king. That doesn't appear. And my Lord, may I just ask leave to hand up a note. It's not heads of argument or anything. It's a note which Malona Jr. did overnight, and it gives all the references to the ITB conduct in the founding affidavit.
Thank you.
Can you just hand those out? And I've got copies for everybody. It's not anything a genius would work up. It's just gives my lord a note of every reference to the Ingonyama Trust. And I'll be referring to that in a moment. If I may just, my lord, before I get into the proper debate about the propriety of the actions of the Ingonyama Trust, if I could just first of all deal with two issues. The first is that we seem to have before us this morning is an application to amend the relief. And we are opposing that application to amend, if it is one, for the following reasons. The first is that in paragraph 3, what the applicant sought to do is interdict the Ingonyama Trust from paying inter alia the legal fees of the king, save for those funds authorized by duly constituted authority prior to the appointment of the respondents whose authority and appointment is being challenged in this application. Now he wants to take that out. That's our defense. How can you bring a case to court and say, I want to interdict something in the future, and I'm excluding what you've done already, and then want to remove the exclusion, and so everything we've said about the way we've acted falls away? What I'm saying, my lord, is it tantamount to them removing the defense that we have. And when I say defense, I'm not saying it's a justification. An interdict is only to protect someone against the reasonable apprehension of future harm.
Yeah.
So to take away the save for means that he's trying to interdict past harm.
No, I don't read it that way. The way I've read this order, and maybe I'm wrong, but can I just tell you the way I've read it, is that, let's call it the Ingonyama Trust, 7th to 20th respondents, are interdicted from using, dispersing, or any manner allocating, paying out Ingonyama money, right?
Yes.
For the personal benefit of the 7th respondent, save for funds authorized. That means payments which have been authorized by the old board. That's the duly
Yes.
constituted authority prior to the appointment.
That's how we understand it too.
Yeah, so you can carry on paying, according to this order, Strauss Daly,
Yes.
because it was authorized by the old
Yes.
board. Yeah.
But that's precisely the point I'm making. If the interdict is against future harm, and this is past news, this is history, and it's excluded as history, and we've made an undertaking to the court that we are not paying any more money except for the honouring the obligation to Strauss Daly, then to take away that is to take away what they've given to us as a right in this application.
But I seem to think that I've put it to the applicants that if I'm going to grant relief along the lines of paragraph 3, the Strauss Daly arrangement is going to
Would
be
have to be excluded.
And they
yes.
seem to accept that.
Yes, well, my lord, I understand that, but my lord hasn't given judgment yet, and
No.
I'm just explaining to my lord that we would have an objection to that unless it comes out in the way in which my lord has just put to me. Because there are plenty, and I know I addressed this in the argument yesterday, but there are many reasons why that should be left alone. The first being that an interdict is only for future conduct, and that's past conduct. The second is that Strauss Daly are not here to defend themselves or to make representations in a matter of their own interest. The third is that it's by no means clear. If one looks at Odekral and the other cases, Kurland, and the other cases that deal with setting aside something that's illegal, there's no certainty at all that this transaction would be set aside.
Which transaction?
the Strauss Daly one.
Oh.
We would have to go through an entire case to come out at the other end to see whether that would be the case. But there's, all I'm saying, my Lord, it is we're asking, my Lord, to be wary of an assumption that it was an illegal transaction and that it should be set aside, save for the presence of Strauss Daly. There are other factors which would suggest, especially if one looks at section 172 1B of the Constitution, which is the just and equitable relief, that there's no certainty whatsoever that that transaction would be struck down. So, and I don't want to defend it. It's an issue which the present board, in their affidavit, has distanced themselves from. They have made it absolutely clear in their affidavit that were it not for the fact that they had been bound by the actions of the previous board and or the previous chairperson, they probably wouldn't have dealt with it. But they were forced to deal with it, constrained to deal with it, on the basis that the undertaking was given and that Strauss Daly would have a legitimate expectation of having payment made to them.
Yeah, well, reasonable people may disagree on whether they were bound to honour that undertaking.
Well, yes, my Lord. Anyway, I'll get to that. I have to deal with that because I want to show my Lord the parts of the affidavit that we believe are important to the resolution of this case. The second point, my Lord, is that on page 29 of the papers, which is part of the founding papers, at paragraph 39,
Paragraph?
39 on page 29.
Oh, sorry.
This is dealing with the composition of the board.
Yeah.
The applicants say that we are the members of the board,
Yes.
and they have cited us as members of the board. And then in reply they say, but we're imposters. This is just absurd, absolutely absurd. So in my learned friend's argument, he said, but there are other people, and he mentioned their names. There are other people who have also got letters of appointment. Well, I want to just clarify all of this, because I think it's important that we all understand where we are. The first thing is that the applicant came to court and named the members of the board who are the respondents, and those respondents have accepted the challenge and are here, present. There is a board resolution where all of those people who are named by the applicant have signed a resolution to give the signatory of the deponent, who's signed the affidavit in this case, authority to do so. So you can't say, well, but these people are imposters. They were cited as members of the board. And the appointment of the current board is a matter of dispute in Part B. So it's been dealt with in our letters. And all the letters are there to see. The third respondent says, or it's alleged that the third respondent went through a process which is the same as what is set out in the Act and did it properly. So it's certainly the trust's case that they are the properly appointed members of the board. And they were cited as such. So where does that leave them? Those current members of the board are duly appointed. Until set aside, their appointments stand. So there's no point in talking about other people and suggesting that there's some kind of confusion about who's on the board. They've said who's on the board, we've agreed who's on the board, and for the purposes of this case, they are the board members until set aside. And that's an application of Kurland and Odekrol. Right, my Lord, then there's a point that we have to deal with, and that's that at the end of the replying affidavit, the point is made that Mr. Ngwengwe, who's the deponent for the board, as the CEO, is not authorized and he must pay the costs. That's contained in the affidavits. That's their prayer, that Mr. Ngwengwe must pay the costs personally of the trust's opposition in this case, because he wasn't authorized to make the affidavit. Now, my Lord, the question of authority, especially in relation to the appointment of attorneys and the signing of affidavits, is a matter which falls under the ambit of Rule 7. And my Lord will know that the full court of this division have confirmed that it's a matter that should not be dealt with in the affidavits. It's a matter that must be dealt with under Rule 7. But they didn't file a Rule 7 notice. But the seventh respondent's attorneys did. I think at that stage they thought, and I'm just guessing, at that stage they thought that the eighth respondent was in fact their client, the trustee.
Yes. I think the notice says the 7th and 8th respondents are asking.
Yeah. The seventh and eighth respondent also started bringing a counterclaim, and then it seems to have been dropped now. So I think they've accepted the point. But they still filed a Rule 7 notice to find out or to question whether Mdledle Incorporated, who instructs us, are properly authorized, and is the CEO properly authorized. And that is the subject of a separate bundle, which very small, it's only 12 pages, and it should be in my Lord's papers.
I think it is.
And it has a Rule 7 notice, and it has a response. And the response is a Ngonyama Trust Board resolution held after the fact. And I'm making that clear. It's held after the fact, and so it comes after the fact that people assumed that we weren't opposing the first Part A of the proceedings and so on. And it makes it absolutely clear that the opposition is to the orders stopping the fund from operating under Part A, and it's signed by all of those people that were cited as the members of the board by the applicant itself. And in reply, there are certain allegations made about this document, but it doesn't matter. It doesn't matter. It doesn't make any difference that they make a whole lot of allegations in the affidavits, because the full court of this division says if you want to attack the authority of someone, you must do it through Rule 7. They didn't bring a Rule 7 notice, and the resolution in response to the challenge by the seventh respondent is before court. It's here. It's a resolution which covers everything ex post facto and authorizes Mr. Ngwengwe signing the affidavit. So we submit that that point is put to bed completely, and in fact the applicant is barred from raising the question of authority either of the attorneys or the deponent by the full court's decision in the ANC caucus case. So that's the first point that I had to get out of the way. The second point that I ought to deal with, my Lord, is it arises from the documents that we put up in that supplementary affidavit and the provisions of the Act. So we should perhaps start with the Act first. It's quite clear, as my Lord Friend Mr. Klopper has pointed out already, that the beneficiaries are the benefit, material welfare and social well-being of the members of the tribes and communities as contemplated by the KwaZulu Amakosi Act. And those communities are in a schedule attached to the Act.
Where does the Act refer to that schedule?
It doesn't refer to them.
It doesn't. Just appears on a schedule.
It's in the it's in the disbursement policy.
It's 2-2. It's 2-2. 2-2 of that.
Two.
2-2 of that.
Yes. Subsection 2.2.
Yes.
Yeah.
I'm sorry, my Lord, did I misunderstand your question?
Yeah. Well, did I misunderstand you? You are talking about the schedule to the Ingonyama Trust Act.
Act, yes.
Yeah. With the long list of areas.
Long
and,
list of tribes.
And clans and
clans,
tribes, yeah.
yes. And those are the people for whom the trust holds assets as beneficiaries. They are the beneficiaries. Dealing with further matters, and this is in substantiation of the point that we made in the earlier argument, and that is that the Ingonyama Trust is a corporate body, it's not a trust. And that is borne out by section 2.6, where it states, in dealing with any trust property, the Ingonyama as trustee shall be exempted from furnishing any form of security, and provisions of the Trust Monies Protection Act and the Trust Property Control Act shall not apply to the Ingonyama as trustee or to the Ingonyama Trust established by section 2.1. Well, I think that the argument that we make is inconsistent with it being a trust anyway. So why it should be exempted from giving security as a trustee, I don't know. Maybe it's just to make it absolutely clear that one shouldn't be confused about the term trust and trustee. This is not a trust, and the trustee is the Ingonyama, who's the chairman of the trust. But apart from that, it's not a trust, it's a corporate body. And it's, with submission, one corporate body, not two. So there have been cases where certain points have been raised about the fact that there's a trust and then a corporate body. And that's clearly not correct from the way in which the statute is phrased. But apart from that, the regulations under the Act make it absolutely clear that it is a corporate body, and further from that, these are now in the regulations which are part of the supplementary affidavit that was filed.
Are those the financial or governance regulations?
It's the the financial.
I think I printed it out separately.
It's RTBS 2, page 1071.
I don't have an index that goes beyond what we had last time. But I've
Well,
got your supplementary somewhere.
it's the second annexure to the supplementary affidavit, RTBS 2. let's hand it. We've got a copy.
Everything's getting cleaner.
It's on the- Lord, we can hand a copy of, an additional copy of the supplementary affidavit. Thank you.
Just as you make the offer, I found it.
I'm sorry to take us back, my Lord, if I could go back to the Act, just as you found it. The definition of Ngonyama in the Act means a person referred to in Section 13 of the KwaZulu Amakosi Act, or a person who acts on behalf of the Ngonyama in terms of Zulu indigenous law, and for the purposes of this Act, excluding Sections 2, 3, 2, 6, 2A3, 3.1, 3.3 and 3.4 means the board established by Section 2A. So they are also interchangeably in certain sections referred to together with the Ngonyama. The board and the Ngonyama are interchangeable. So with that, my Lord, if we could go then to the regulations.
Am I right in thinking that the Ngonyama has no powers
No.
beyond those he might exercise with the board
As a chairperson.
as the chairperson?
Yes.
So in effect, for decision-making purposes, he can do nothing on his own.
He can be outvoted completely.
Yeah.
He doesn't have any casting vote. He's the chairperson.
Yeah.
And there are all these other members of the board as well. And that is important because it places a certain emphasis on certain things that are said in the affidavit, where it says that the board has explained to His Majesty the following. That means the majority of the board have told him X, Y, and Z. So, Lord, if I could then go back to RTBS 2, which is the financial regulations. The first point to note is that the accounting authority means the board. So the accounting authority is not the king.
Yeah.
The board is defined as the KwaZulu-Natal Ngonyama Trust Board, established in terms of Section 2A of the Act. The chairperson means the Ngonyama or his or her nominee, and the trust means the corporate body established in terms of Section 2 of the Act. These regulations apply to the financial administration, Section 2, of all income earned or accrued to the trust and are subject to the provisions of the Public Finance Management Act. And that's extremely important for the purpose of this case, because we have said as an alternative remedy, you've got the Auditor General and you've got the PMFA, and money is protected. You don't have to worry about that. That's basically the point that's made. The accounting authority, i.e. the board, has its powers set out in Section 3 of the regulations. And what is also important about the regulations is that Section 20, audit. The financial statements and records of the trust shall be audited annually by the Auditor General. And then there's a report by the Auditor General to everybody who's interested, including the National Parliament. And the Auditor General's report must be discussed at the first meeting of the Accounting Authority after the report is received. So it makes it quite clear that this is an organ of state and it's dealt with under the constraints, the financial constraints of its own regulations, of the PMFA, and with oversight by the Auditor General. And Lord, just to complete this
Of course,
part...
that only works.
Pardon, my Lord?
That only works if the board submits its financial statements.
Yes. This is a new board, my lord. As my learned friend Mr. Klopper said, it's a new board and it's revisiting everything that has been done in the past. In fact, the first meeting, as they say in the affidavit, on the very first meeting they confronted with this crisis.
It wasn't supposed to be a meeting.
It was supposed to be an inaugural meeting where they all met each other
Yeah,
and
it had to turn into a
congratulated-
working meeting.
congratulated each other on their appointment.
And then they wished they weren't appointed.
Yes, that's but Lord, the last point about this, I'd like to say nail in the coffin, but the last point about this is that in the case of Etukwini Municipality versus the Ngunyama Trust, in the Constitutional Court, Justice Jafta set out the definition of organ of state in the Constitution and found that there can be little doubt that the trust exercises public power and performs functions in terms of legislation. Therefore, it constitutes an organ of state. And the reference of that case, that's not in our heads, Lord. The reference of that case is 2014, Volume 3, SA 240, Constitutional Court, and it's paragraph 37.
Yeah.
So, the ultimate conclusion of this part of the argument, my Lord, is that when the applicants come running to court and make very few allegations which are serious, a lot of them are very old, out-of-date allegations, they fail to mention that they know they're dealing with an entity which is an organ of state, which is covered by the PMFA, which is audited by the Auditor General. Because at those paragraphs that we've given my Lord as a compendium of everything they've said about the trust, the only 2 points that stick in relation to something that approaches an allegation of unlawful conduct. The first is you are paying the fees of Strauss Daily, but that was struck out because it was hearsay. So the one thing that they really had a point on was struck out. The second point is that they, and my learned friend made a point of this, he said we sent them a letter of demand or a letter to cease and desist, and they didn't even respond to it. That letter was dated the 23rd of May 2023. It's PM6. It's referred to on pages 61 and 62. I beg your pardon, paragraphs 61 and 62, pages 39 to 40. And it demanded an undertaking within 7 days. And the allegation is that no response. And the response of the board is set out at page 233.
Page, sorry,
233.
273.
Ah, no, hang on. It's not 233, is it? It is 233. Now, where does it talk about the, I'm sorry, my lord, where does it talk about the emails? There it is, there. That's
Paragraph 91.
yeah,
I can use my page. 233.
233.
No,
Oh,
223.
I'm sorry, my lord, I've just had a problem with my dyslexia. So the answer is given at page 233. I was correct.
220?
Beg your pardon, my lord?
What page must I go to?
233.
Why am I at 273?
Perhaps we've got the same problem.
That's concerning.
At page 233, it deals with PM6. And it says it was never received by the officers of the trust, and more especially the CEO, RTB, and the trust CEO learnt of the aforementioned letter for the first time upon reading these revised founding papers of the applicants in the present matter. In other words, it wasn't in the first run, the dummy run that preceded this application. They read about it for the first time in these papers. When considering same, it was noted that the letter was allegedly delivered by way of electronic mail addressed to 3 email addresses: ngobo@ngonyamatrust.org.za, paminister@daf.gov.za, and mlominister@daf.gov.za. Firstly, there's no person currently employed with the name Ngobo, and it submitted the applicant's attorney would have received notice of failure to transmit the letter by email. And then it goes on to say that the Department of Agriculture and Land Reform is no longer DAF, and so that would have come back as well. In other words, no one got that letter, and not only that, as a matter of probability, they have set out facts to show why they didn't get the letter. So we submit, my lord, that one can only come to the conclusion that that letter was not sent to the right people. So that would also be a stumbling block in our case. If we'd got a letter like that, why didn't we respond within 7 days? That's the answer. We never got it. But not only that, the date of the letter is before the inauguration of the new board. That is at 223. This is where I got confused just now. This is 223 in the affidavit. In paragraph 52, under the heading of challenges faced by the current board, the newly appointed board had its induction meeting on the 19th to the 23rd of June. That's a month after the letter. So no one got it. It wasn't sent to anybody with who would have received it, and so the 7 days passed without being complied with for very good reason. So those are the two things that are now that we should be worried about. The Ngonyama Trust, as an entity, would be worried about the two things in their affidavit. The one is the Strauss Daily contract, about which has been struck out, all the detail has been struck out already, and the second was a letter which was never received. So this all deals with past conduct. Obviously, the failure to reply to a letter could be used by an applicant to say, well, I've written them a letter, I've warned them against doing this in the future, they don't even reply, So I'm now entitled to an interdict preventing future conduct. But now we know, my lord, with the benefit of hindsight, that the letter wasn't received. And not only that, the Strauss-Daly transaction is water under the bridge, which is now dealt with in paragraphs 52 through to 60. And in all those paragraphs, it's quite clear that the Ingonyama Trust is saying that they had doubts about this. They didn't think they had an obligation to pay legal fees to the Ingonyama, but it had been, that an undertaking had been given. Not only that, they found letters which they put up on their affidavit between the previous chairman to Strauss-Daly and to the bookkeeper, Mrs. Patu, and that then comes out in a board meeting of the Ingonyama Trust prior to this board's inauguration, relating to that transaction. And given all of those facts, they made a decision that they would have to comply with the obligation and not renege on it.
Of course, the Strauss-Daly issue is not water under the bridge
No,
insofar as implementation is concerned.
no,
Because
it's
on the
continuing.
papers, they're paying
it's
monthly
continuing.
installments.
It continues, and we did try and do a calculation of where it is at the moment, and our understanding is that it has been complied with. So that means that,
There were 26 installments, as I recall.
yes, 26 installments. There was a R1 million upfront payment, which was paid, and then there are 26 installments, and they are about halfway through. No, I don't agree with that.
I don't believe it's disclosed on the papers as how much the installments are. And if it's not,
No, it is, my lord, it is. It's just a question of me finding it. It's 200 and something thousand a month. We'll find that. We'll find that, my lord. So the board has been completely upfront about this issue, even though it doesn't reflect very well on the previous chairperson, and possibly doesn't reflect well on them. Depends who's doing the judging. Certainly, Strauss-Daly would approve everything they've done.
It's ITB 13,
It's ITB 13 at page 262. The installment is there set out in paragraph 2.5. It's 205,246 rand and 10 cents for a period of 26 months, and that's about halfway through. So then,
we've gone past the commencement of the long adjournment.
I beg your pardon, my lord?
We've gone past
Oh, I'm sorry,
the
1
appointed
o'clock.
time for the long adjournment. It's 1:05.
Sorry.
No, you don't have to apologise. We will finish this afternoon.
Yes, we will.
Yeah, I think so.
I don't have much longer to go.
Very
And
well.
I'm last except for Mullen, no, not Mullen Friends Jr.
Very well. We'll rise for an hour's the long adjournment.
I've got sandwiches again. Are you tired of them? Okay, let's go and have them.
Well, I'm literally like testing your stuff.
identified as beneficiaries. And the disbursement policy seeks to encourage all of them, all of these entities or groups of people, to set up community organizations, which for the benefit of the board in making payments. So instead of going and scattering notes all over a particular area, you have a community organization and they get a payment.
Yeah,
And then
well,
that's
we're getting
distributed.
buried. I don't know what the board is doing distributing money. It's supposed to be administering land, and in other words, roads,
At a
river
certain-
crossings,
No, at a certain stage
all
they did
sorts of
have money.
things. I beg your pardon?
At a certain stage they did have money.
Ah,
It may have been that the judgment that my lord was part of may have struck down one source of the money, but there are sources of money,
yeah.
and there's land and there's money, obviously, because the disbursement policy refers to the distribution of certain monies. And all I'm saying is that the disbursement policy starts off in the right direction by identifying entities that can be paid with the view of getting them to a group of people. And if you have an organization, then you don't need to pay any money to, for example, the Nkosi. So the board will, as a guide, distribute, that's on paragraph 3.3, and it gives the 75% to traditional councils and community areas, and then the 10% for the distribution to the Nkosi, and then 5% will be made available to the trustee, that's the Ngonyama, in terms of the Act. This would be utilized for the affairs of the trust as per the provisions in terms of the Ngonyama Trust Act, and would be made available for the distribution for the benefit, etc., of members of tribes or communities in areas less well endowed. Whatever all of that means, it doesn't say anywhere that legal fees can be paid.
Doesn't say anywhere that?
Legal fees can be paid.
No.
It doesn't expressly set out that legal fees can be paid. There is a paragraph which deals with certain issues, personal issues, 10.7. which identifies that certain benefits could be medical aid, funeral aid cover, etc. And those are named as expenses that various people amongst the beneficiaries may have. So someone has to make the connection between services or services that are required by the Ngonyama or the people of Zulu origin, between the benefits and legal fees. We're not doing that. We're not asking the Lord to do that. That's someone else's job to do, and we're not going to do that. And it makes sense because the affidavit that has been filed is consistent with what I've just told you.
Yeah. Mr. Dixon, there is an attempt in the affidavit to classify this disbursement policy as in fact the law affecting matters.
No, it's not the law.
It's not, yeah.
No.
The board
be
is
changed
entirely
tomorrow.
free to correct this policy, and with respect, that's what it ought to be doing. If it's
Yeah.
unhappy with it, it must correct it.
That's so, my Lord.
But it
and
doesn't affect this case.
No, it doesn't affect this case, and I've no doubt that it will be changed. As my own friend for the seventh respondent says, the new board is in a period where they are revisiting everything.
Yeah.
And I can certainly confirm that. But what I need to do then is go to the affidavit, because you've got the disbursement policy and then you've got what the present board want to do about it, or say that they can do about it. And that's why it's important. It's important that what they think it means is something like what it means, because otherwise my Lord will interdict them if they're wrong. And if they're right, then there's no need for an interdict. So that's the reason why we're asking my Lord to look at these carefully. And this morning I went through the issue of the Strauss Daily obligation, and that is dealt with at paragraphs, this is page 225. And it's at paragraph 59 and 60. And then the important parts are from now onwards, the ones that I'm going to deal with. That's in relation to whether an interdict is justified. At paragraph 61, the board resolved that the instalments due to Strauss Daly would be taken from the 5% of the trust income which is allocated for projects and causes of the Ingonyama.
Yeah.
You've got to get it from somewhere. And that's what they decided to do. 62. During a meeting held with the Ingonyama, the CEO and the chairperson, this is before the 7th respondent took over as the chairperson, and vice chairperson of the board representatives explained to the Ingonyama that payment of his outstanding legal fees was the only payment that would be given for the next 26 months, since the 5% would become exhausted by the commitment to Strauss Daly. Although the board subsequently decided to cease making payments or disbursements which were of a personal nature and not within what is permitted by the disbursement policy, this message had not been conveyed to the Ingonyama at the time that the current litigation commenced. And then, my Lord, at paragraph 68, the conduct which the applicant seemed to complain of against the trust and its board is conducted historically, perpetuated through and by the current board's predecessors. The present board has taken serious steps to ensure that it brings the trust back to a place of compliance with legislation and its policies. Therefore, it would be improper for the applicants to persist with the relief it seeks against the 8th and 9th respondents. Now that we submit is an undertaking to comply with the law, and that then takes us to the National Treasury case at paragraph 50, where the following is said: under the Settler-Gallows test, the prima facie right a claimant must establish is not merely the right to approach a court in order to review an administrative decision. That's exactly what's happening here. They want to review the composition of the board, which is an administrative decision. It is a right to which, if not protected by an interdict, irreparable harm will ensue. An interdict is meant to prevent future conduct and not decisions already made. Quite apart from the right to review and set aside impugned decisions, the applicants should have demonstrated a prima facie right that is threatened by an impending or imminent irreparable harm. Impending or imminent irreparable harm. The right to review the impugned decisions did not require any preservation pendente lite.
Yeah.
Now
Can I
that,
just have the reference to that case?
it's in our heads, my Lord. It's National Treasury versus Opposition to Urban Tolling
The
Tolling
OTA
Alliance.
case.
It's the OTA case, yes.
Okay.
And it's at paragraph 50. And my little friend, Mr. Kloppers, he dealt with certain parts of this, which I'll get to in a minute, but that's the prima facie right. So what we would ask my Lord to do is to search through the founding papers to find, apart from the right to a review, an interim measure to cope with the threatened impending or imminent irreparable harm. And we submit there's just nothing there. And when the board is given an opportunity to respond, they say, look, we got caught by the previous chairman. We had to pay this money. It was an undertaking that was given by him, but we're not doing any more. And he's not being paid anymore, and we've actually told him. Now, it's since then, it comes out in the replying papers, since then the Ngonyama has assumed the chairperson's role. But that doesn't change anything.
It doesn't change anything, no.
No, he's just the chairperson. He's got the rest of the board associating themselves by resolution retrospectively with what has been placed on oath already. And that board says we're not paying him any more money. Apart from the fact that we haven't got any because the 5% is depleted, we've explained to him that this is not for legal fees. It's for other projects. So that is taken further in paragraph 68 and 69, where it's stated that the applicants are improperly asking for an interdict because we've undertaken to them that we're not doing the things that they fear. And we've set out chapter and verse and given lots of facts to bolster the probability of that proposition by showing that we don't have the money anyway. It's all gone. It's gone on something that the previous chairperson made us do. So that is then taken further at paragraph 229, paragraph 74, 75 and 76. First of all, there's a denial that the current board is engaged in any unlawful dissipation of the trust's financial or other resources. It's denied that the ITB and the trust are in any way aiding any alleged unlawful conduct of the second respondent. That's specifically denied. As previously provided, the ITB is a creature of statute and therefore bound by the prescripts of the law. It is therefore further denied that the trust and the ITB are in any way undermining the rights of any of its beneficiaries. 76. The 8th and 9th respondents deny that they have taken unlawful decisions or will continue to do so if the order sought is not granted. That's the allegation made against them, that they're taking unlawful decisions. Reference is made to the averments made herein above in this regard. And then the same is also said in paragraphs 84, 85 and 86, where in 84 it stated, although the Ngonyama is the figurehead identified as the trustee of the trust per the RTA, it's the ITB which holds fiduciary duties in respect of the trust. Therefore, it is denied that the 7th respondent has free rein with respect to the trust's assets and resources. It is further denied that the 8th and 9th respondents have acted divisively, creating divisions within the Zulu royal family as alleged, and that they are not providing unlawful support to any persons. If anything, the newly appointed ITB have upheld their independence and are undergoing a process of ensuring that the trust and the ITB adhere to the RTA and conduct their affairs in a manner which complies with the prescripts of the law and the internal policy. There's nothing within the operations of the trust and the RTB which requires intricate involvement with the royal family in any way. And my Lord will also have noticed, although I don't want to go into it, there is quite a lot of expense that's uncovered from the past in relation to hotel expenses, travelling expenses to meetings and so on.
Income tax.
Yes, that too, my lord. And this is now on members of the royal family other than the Ingonyama.
The
So,
tax.
Other than the Ingonyama.
Was it not the Ingonyama's trust, tax?
No, my lord, it might have been his tax, but there was certainly, I think the first applicant stayed in a hotel.
Oh, that was travelling, yes.
Travelling.
But I'm talking about the tax, paying
Yes.
somebody's income tax.
Yes, this is so. So one must be candid about this, and the new board is candid about it because this is their affidavit. They're actually telling, my lord, what happened under the old regime, and they're saying that we're not going to be held accountable for this. We are accountable under the PFMA, we're accountable to Parliament, we're accountable under the regulations, and we're not going to be doing any more of this. And so if you want to look to anybody, look to someone else. Look to the previous chairperson. Now, in the light of all that, it would not be, with respect, right for them to be interdicted from doing anything in relation to, as I understand it, legal fees only now. Because even though that then may avoid the constitutional problem of the separation of powers, if one restricted it to just legal fees, then it would still be wrong to give an interdict against someone. I mean, there are hundreds of examples of someone who gets smacked in a pub and he gets a letter of demand and he turns around and he says, I'm terribly sorry, I was drunk, didn't know what I was doing, I'll never do it again. You can't get an interdict against that person. He's already told you it's wrong, he agrees with you it's wrong, and he won't do it again. That's what the board is doing here. Not that they've smacked anybody, but it's the example by analogy that you cannot, and again it's paragraph 50 of the National Treasury case, you can't punish someone for previous conduct. It's only the impending and irreparable harm. And that's not going to happen, not under this board.
The argument that the late Mr. Justice John Didcot used to raise against your example is, well, if you're not going to hit anybody, what harm does it do if an interdict is granted against you?
Yes. I understand that, Lord, but that's what we're trying
But
to
it
avoid.
implies guilt. Yes.
Yeah. That's what we're trying to avoid. And in fact, it all depends on whether the undertaking is believed by my Lord. And there's no reason in this affidavit to suggest that this is not honestly and candidly and bona fide put up to court to say, you don't have to interdict us. We know what our job is. Things happened in the past which we had no control over, but we are not going to do this. Despite the fact that my learned friends for the 7th respondent believe that it's possible to do it. Certainly the board, the people who authorized the CEO to make this affidavit, don't see it that way.
Yeah.
And then, Lord, the point is taken further, and I don't want to labour this too long. I know we're running into Friday afternoon, but if I could just say that the balance of convenience is set out by the deponent in paragraphs 104 to 106, pages 236 to 237. Because they say there's no threat of the stated harm happening. And then they go on to say there are alternative remedies. They can always ask for the trustees to be held account under the PFMA or the regulations or in Parliament.
Yeah.
So that with respect deals with the irreparable harm, even if it's established. And we've given, my Lord, the references to the Ingonyama Trust's conduct that they complain about. And they are largely, I don't want to be unfair, but they're largely insulting statements so wide that you don't know what you've done wrong. Except for the letter, which I've dealt with, and the Strauss Daily complaint, which we've also dealt with. So, Lord, that will then end up with looking at paragraph 65 of the National Treasury outer case, which my learned friend has already read to my Lord. You have to assess carefully how and to what extent its interdict will disrupt executive or legislative functions conferred by law, and thus whether its restraining order will implicate a tenet of division of powers. When a court has the power to grant a restraining order of that kind, it does not readily do so except when a proper and strong case has been made out for relief, and even so only in the clearest of cases. Well, in this case it's not clear and it's not strong. It's in fact general, wide-ranging and largely invective rather than facts. So we would ask that the interdict should be dismissed with costs. Lord, there's a new 67A, a Rule 67A, which requires my Lord to certify that certain costs should be granted. There's an A, B, and C scale. We submit that this is a very important and complex and large case in the normal scheme of things. And although it only starts from the start of Rule 67A, which I think was in February this year, February. It was only in February this year. There's a case called Mashava by a recently appointed judge in Gauteng called Wilson J. And Wilson J has examined Rule 67A. He found that it only it's not retrospective, so it only starts from the date. So it only covers appearances and attendances by counsel from the date it started, and we submit that from that date our costs should be awarded on the basis of C, and that it includes the cost of 2 counsel.
Council, all council agree that is where I have to make a cost order. That is the one, that's the basis upon which should be done. Scale C, cost of 2 council.
Yes.
Apparently, my Lord, I'll get the message from along the row here. Apparently, my Lord has to certify that it's C for each council, for both council. So that
Do
means
I look
that
like a taxi master?
well, I didn't know that was necessary. I read Mashava's case, but I was concerned about the seniors' fee, not the juniors' fee. I must confess.
Thanks.
But I must protect Melina Junior, and if it's required that she be placed on 2/3 of C, that's what we ask for.
I don't stipulate the percentage.
No.
And are you not talking about Rule 69?
No, 67A. It's a
67.
brand new rule. And
Yes, I
it's-
know that it's a new. I thought it was a new Rule 69.
No,
No.
this is only for what you can recover from the other side anyway.
Yes, yeah, no, I understand it.
And apparently, if you get an attorney and client costs order, you don't need to categorize the class A, B, or C. It's only when you're asking for an ordinary order of costs that you have to, the Lord has to tell us that we're entitled to C. Otherwise, we only get A, which
Yes,
is
all
like
right.
magistrates' court costs.
Can I please hear from the leaders about your juniors?
I've only got one junior.
Mr. Dixon, what scale? B, perhaps? Or what?
C.
For the juniors.
For the junior is
Because it's a monetary scale.
Yes, it is.
So you're saying that in party and party, the junior and the silk get paid, are
No, they
charged
don't
out
get
the
paid
same.
the same. Yes, I think, my lord, it's right. The junior should be B and the senior C. That's what I'm asking for. You happy with that?
Sorry, I'm just going to round robin this before you finish.
My lord, may I just make it quite clear? This is only on the basis of recovery.
Yes, I know, I
It
understand.
doesn't prevent us
It's the
from
old
charging.
party and party bill.
Yes.
For the applicants, what's the scale for the juniors?
I think what Mr. Speaker said is
It's probably right.
that's what we would. I mean, I have 2 juniors, so I suppose it will be a sliding scale.
Yeah.
I'm not sure how it works, but
Yeah. I can't remember now about the junior, but I do know that scale C is remarkably high. Because whatever figure you see in that table there, it's per 15 minutes.
Pep, can I ask that we give you a note on Monday on the costs?
But you're going to send it to me in Scotborough.
Sorry.
Are you going to send it to me in Scotborough, where I'm going to be sitting hearing crime from you?
You tell me how I can do it. I even thought about what is
yes,
raised.
I know.
And it's
Can we
a
not
fairly
agree?
new area, so
We'll get agreement from you now for C and B.
yeah.
C and B,
Yes, C and B and in 3 council.
but I don't think I can justify 3 council.
Well, it's within your discretion,
Yeah.
Lord. So we're quite willing also to fall in with a note, but otherwise we are a 3 council, and it will be C, well, the same scale approach.
C and B. Yeah.
Yeah.
Then anybody who has a good look at the rule and decides that they better send a note can do so.
Thank you.
This is a matter of interest. C is 4,500 an hour
An hour. Oh, is it not per 15 minutes?
and 45,000 a day, if it's translated into a day. I think for the purposes of 67A, it's actually got an assumption that a day in court will be 10 hours. I might tell you, my lord, that most silks in Durban charge that without blinking.
But now it's recoverable as between party and party.
In fact, I'm getting a vibe that it's quite small for Joburg.
Now, Council for the national and provincial governments have not opposed this application. And you've come to explain yourself. I think it must be at your own expense, or am I wrong?
My Lord, I think we should take this under advisement. But it's something which I've also recently heard about from my learned colleague here. I had not been aware of it, so I'd have to look into it and find out. Really.
Yeah, no, I'm not talking about that.
Yeah.
The applicant has said it only wants costs against parties opposing,
Yeah.
which presumably is one of the reasons why the national government and the provincial government each decided they wouldn't oppose.
Yes.
They would simply try and be helpful.
Yes.
Now, if the applicant is unsuccessful, on what basis can you now charge the applicant for being helpful, as you should be as government? Surely you have no claim for costs. Or am I wrong?
I think we have. Lord, I'll have to look and see what we say in our. I seem to recall something about.
Well, I
something
can't remember whether you've claimed it or not. I'm suggesting to you that the route you chose to come to court
Yes.
freed you of any potential liability for costs.
That
and
is-
I've always understood that if you do that,
Yes.
it works the other way around as well. It means you have no claim for costs.
Well, that is what I'll take under advisement.
I'm going to proceed on that basis unless I receive a note. Is that all right? Okay.
My Lord, from the province's side, I would also need to take it under advisement, but I hear His Lordship's concern.
Yeah.
And of course, hopefully will not become an issue of whether it's been budgeted for or not.
Sorry, before we hear the reply, there's one other thing. I received a letter, you will recall, from it was applicants' attorneys? Yes, advising me that they were not going to pursue paragraph 2.2. In that letter, the suggestion, it is recorded that a suggestion has been made that the application, the vexatious proceedings application, should be adjourned or not proceeded with during these proceedings. It wasn't clear in the letter as to whether that's by agreement or whether it was simply a proposal from the applicant's attorney. I've heard nothing about the application today. How am I to treat it? As abandoned or what?
The application is very much live. It was brought on the long form of notice of motion. In other words, not to be part of the urgent proceedings.
Okay.
And in the heads of argument, towards, in the last paragraph, we made it very clear that we will not be proceeding with that application during these initial proceedings,
Right.
and stands over for the main.
So
for
it
part
hasn't
B.
served before me at all?
No.
Okay. Right. Mr. Dixon, are you done?
Thank you.
Thank you. The reply.
I won't take much of everybody's time, especially yours, and I won't cover really everything. What I purport to do is to just comment on a few things that my learned friends raised, just to solidify the main arguments that were made. The first issue I'd like to address is that of locus standi. I think if my Lord would look at the first 5 applicants, the way they are cited, just to make the point clear, you'll see there that, for example, the first applicant is Prince Mbonisi Kapegu Zulu. Kapegu Zulu is the 7 respondents' grandfather, and the first to 5th applicants' father, and the late king's father. And based on that, and that is the royal family, and that is the Indlu Kapusha that is referred to in the papers, which is the house from which the 7th respondent comes. Now what that means, and the point I'm really making, that there should be no issue, and it's unfortunate, and I'm embarrassed. I've been a Zulu for a long time and I practice the culture. It's embarrassing.
I'm sure you were never anything else.
And it's kind of embarrassing that one is put in a position where the 1st to 5th applicants have to effectively present their credentials before court, and especially present their credentials to the 7th respondent, who is effectively their son. So in that respect, I wish to say no more on locus standi. Safe to say that Indlu Kapusha, which is in the schedule to the Royal Trust, is the tribe from Osuthu. It's the late king was Isilo of Osuthu, which is that community tribe. So when the 1st to 5th applicants bring these particular papers before this court, they are not only, as indicated, coming in their personal capacity as members of that Osuthu tribe, but they are blood relatives of the late king, of the 7th respondent, and they are the royal family, irrespective of who else thinks somebody else is a member of the royal family. But this is the core. If the situation, for example, was that the 7th respondent was not currently a monarch or a king, which will be dealt with in the SCA, the most senior member of that family to whom everybody gives deference is the first respondent. So in that first applicant. So in that respect, my lord, I wish to not deal further with the issue of locus standi. Safe to say that it's sufficiently established. The issue of non-joinder of various parties, I think your lordship got it quite correct that based on the orders that are sought today, everybody that needs to be here is here, in the sense that with respect to the trust board, they are here. The members of the royal family that it was suggested should have been cited are not necessary for this particular application, and they are correctly not here. They wouldn't assist this cause in anything of the sort. So there is no issue of non-joinder. Similarly with lease pendants. The issues that may be, although we don't, we do dispute it, but any issue that is suggested exists and is currently pending elsewhere doesn't relate to anything that is sought in these particular orders here. So lease pendants doesn't apply. Then the next point, my lord, is the clarity on the issue of the allocation in the vote by the Premier's office. And the reason why I bring this is because it just emphasizes the point that's been made, and which the learned friend for my learned friend for the Premier clarified, and we agree with that clarification. And it is that if you look at page 536 of the record, that allocation, and the lordship got it correct, that this side of the bench would be smiling if that allocation was available to everybody. Indeed, we would. There's just one slight difficulty with it. If one looks at this allocation proper, and as we're dealing with the amendments starting yesterday and today of the orders, your lordship got it correct that isn't this just about the fact that this is a legal challenge about the extension of funds to the seventh respondent to challenge the issue of his status. Who does that involve? That's not the legitimate business of government. It doesn't involve...
Not a legitimate what?
The issue of the seventh respondent status is not normally in the course of legitimate business of government, for argument's sake. It's a private family personal issue because it's about the identification of the successor by the royal family.
But Mr. Similani, that's only part one. Part two, in which the first applicant was successful in Pretoria, is the ultimate hurdle. You've got to be recognized as well. And that's essentially got to do with the government and the President of the Republic of South Africa.
No, indeed, I take that, my lord, in this sense, though, I'm making the point in this sense, that the essence of who is involved in this contestation, it is actually the seventh respondent vis-a-vis his siblings. And
well, some of them.
At least those that are known, some of them, yes, those that are known. That's the first part of it. The second part of it is that the applicants, it's the first to fourth applicant, are the primary people responsible for conducting that exercise of getting to that point. And that matter is being dealt with elsewhere, and we'll see how it unfolds. The bottom line is that if then the provincial government in the office of the Premier, in their program 3, under that department of the Premier, gets appropriated from the provincial legislature 30 million rands, 15 million of which would fund a particular contestant, in this case in the form of the seventh respondent against his siblings. That is the point that was being made. There is no legal authority for that to be done by the office of the Premier. And from that perspective, the challenge and the interdict with respect to that allocation stands, and the Premier correctly doesn't oppose that because it is an issue. With respect to the other 15 million, which then goes to the Royal Household Trust for legal fees, that fundamentally is not a problem because those legal fees can be used by the royal family, including the seventh respondent, for any other legal matter involving those members of the royal family that appear in the Royal House Trust. But it can never be used for this specific purpose for which the matter in Pretoria is being dealt with now.
Well, you make that assertion. Will you tell me why it's right? with reference to the law on the subject of what the House Trust can do?
What the House Trust can do, my lord, is in the specific legislation. The welfare, the well-being of the royal members of the trust, their upkeep, their salaries, all of those issues are legitimate. We have no qualms with that. There's no qualms with that. All of them, every single one of them. But when the internal issues, core family, so the issue of the royal family is this, is that firstly you have a family as I described earlier, of which the seventh respondent is a member, with his siblings and his uncles and aunts and so forth. Then you have the role of that particular family in the broader context of the kingdom, the Zulu nation, and the royal family.
Yes, Mr. Simonori, I understand all of that.
Yes.
But you're missing the point. It's not a question of who is causing harm to the king.
Yes.
That's not a question that has to be answered before a decision is made as to whether the cost of protecting the king against that harm can be incurred by the household trust. It's a question of what is the harm that's threatened. So if there's a threat to the life of the king, which results in an increased cost of security,
Yes.
the household trust doesn't look at who's threatening the life of the king. It looks at the question as to the harm and says, yes, we can alleviate this harm, we will pay for extra security. And now,
Yes.
in this case,
Yes.
the question is, the harm that is sought to be perpetrated is the removal of the king from the head of the royal family, from his position as head of the royal family. How can I decide on these papers that I can stop the household trust from protecting him against that? And please don't tell me it's because the rest of the royal family are trying to remove him, because that's not relevant. Doesn't matter who's trying to remove him. Can I, on these papers, tell the household trust, which hasn't been joined, that you can't pay legal fees to protect him against that?
The issue is with respect to the premium. The 15 million that the household trust has been allocated, the household trust can use as it deems fit for those legal fees, as it deems fit. That's legitimate. We have no issue with respect to that. But with respect to the premier, allocating the 15 million specifically for that litigation, it is that with which we raise these concerns, hence our application.
Yes, I know, but I want to know, yes, you're entitled to say we don't agree with that. I want to know whether it's established anywhere on these papers that it's unlawful.
We've not been able to find a basis for it in the provincial government and the Premier's office areas of responsibility, my lord. What would have worked better, Dada, is that the full 30 million is allocated to the Royal Household Trust for it to be spent for those legal fees. The amount, I see my lord's face, the amount may really be high, but they may very well be.
The whole 30 million is allocated to the royal household.
No, my lord.
It just the opening sentence that of paragraph 536, third bullet point.
Which paragraph, my lord?
Paragraph everybody's been looking at. The 30 million was allocated to program 3 towards legal fees incurred by the royal household. What the person who's drafting the budget for the Premier is then saying, of that 30 million, 15 million is to go towards His Majesty's costs, and 14 million is to go to the family's legal costs, the royal family's legal costs. In other words, their costs other than those of the monarch. That makes up the 30 million.
I'm reading it, my lords, to say the splitting of the funds is where the problem occurs. Because the 15.6 million is to cater for His Majesty the King's legal costs.
Yes. So
And the way we read it.
the royal household must spend that 15 million on the king's costs, and it can spend the other 14 million rand on the costs of other members of the royal household. That's what this paragraph means. It's clearly stated in simple language.
As it pleases the court, I will not take that issue any further.
Thank you, Mr. Simon.
Thank you. With respect to the trust board, with respect to the trust board, the issue there is that we again could not find any legitimate spending that the board could incur for purposes of the 7 respondents' litigation in this particular case. And the point we make there is that the disbursement policy doesn't provide for it, and there's a problem with it, and we accept that there's a problem for it for everybody. Now, what is proposed to be done is to pay the remaining amounts from the 5%, which is a discretionary amount given to the monarch. The challenge with that is that 5% the monarch is supposed to spend for purposes of development of communities, not for this particular purpose. And would submit that that should not be allowed. We know, and I heard my learned friend saying, the money must be found from someone. We have reservations and difficulties in accepting that somewhere must be in this 5%, which is specifically meant for communities in the disbursement policy. And we thought we'd re-emphasize that particular point. Now, the interdict that we seek, correctly, and we've all agreed, and had we had an opportunity to have an engagement with our learned friends for the board, in all probability the issues would have been resolved, because indeed we accept that this is for for future conduct that should be
It's a
integrated.
great pity that your letter did not reach them.
Yes, indeed, it was a pity, and we hoped would have that resolved. My Lord, having covered those particular aspects, I think what is clear is that the applicants do meet the test and the standard for the granting of an interim interdict. The harm is clear, and the harm that they are seeking to protect is not only their personal interest, but it's the interests of the tribe of Osotho from which they come, and it is the spending of the money by the board that would be ordinarily meant for those particular communities, of which they are one, and therefore any spending of any amount whatsoever attracts that kind of attack for that particular reason. The balance of convenience we submit on that basis favors the applicants, because indeed this is conduct that should correctly be stopped and which borders on maladministration, if not unlawfulness. So it's a legality issue that the protection of the resources, financial, of the communities should be protected from being spent in the manner in which it is currently, or at least we understood was proposed. So we're glad that the board undertakes not to do that. What hasn't been clarified though, and would have liked to hear, is the 205,000, the 205,000 in installments. We understand that the board gets its money for administrative purposes from national government, including some grants. We've not been advised whether or not that option has been looked at as the source from which, with the approval of national government obviously, from which if any assistance is sought to be made to the 7th respondent, be considered from that end, but definitely not from the money meant for the communities. We thought that's something to weigh heavily on everybody. With that, my Lord, I have nothing further to say. Thank you.
Your leader made a promise that you would deal with paragraph 5.
Oh yes,
yes.
my Lord, of the notice of motion. We did discuss it, my Lord, and what
Applying to amend.
Eh?
It will be applying to amend.
what we're going to hope to amend paragraph 5 to read would be
Pending.
along the lines that Your Lordship also mentioned, that interdicting and restraining the 4th and 5th respondent from utilizing or authorizing in any manner or form the utilization of any public funds and resources in relation to litigation for the protection of the status of the 7th respondent. Pending Part B of the application.
Sorry, in relation to litigation. Sorry,
Litigation relating to the protection of the status of the 7th respondent.
Okay, so both 3 and 4, they coupled on the tote, to use horse racing terms, and 5 are going to be subject to the final determination of Part B.
As pleases the courts, that is indeed so.
Yeah, I've got that.
Pleases the court, I have nothing further.
All right, so I may or may not get notes on this question of the new rules relating to costs. And I may or may not get notes from the national and provincial government lawyers on the subject of whether they have any claim for costs at all in this case if the applicant is unsuccessful. Subject to those qualifications, my judgment is reserved. Before I rise, can I thank counsel and the attorneys for the efforts they've made in this case. It's been most helpful. Court rises.
Court, please.
Husband for what? They're coming to abide it. Put it away again. Leave this issue of a course, man. Have a safe day.
Someone else paid some part
And then
They only want transport anyone. You only have this honor this agreement that was made by Pennsylvania, and then nothing else. And then the 5% of special police that is
just
That's correct.
I don't know how to